Number 2.
Last month I did utilize the Zoom for Calhoun County. So, because I didn't need to be on, but I did have to come on and see what they did. I just left it on in the background. It was 4 or 5 people watching.
I said bacon. I bet.
Yeah, 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 it's not very.
He's gonna be here. He's stuck in traffic. He's gonna text that he's running a little late. So that's the matter. He should- I just got a message from Jennifer that.
Ooh, son, I'll talk to him.
Okay, if it looks like something, just send it back to us. That'd be fine.
We don't always get all the files, but they broke us over. We get better code.
Okay. Okay.
Megan, can you hear me?
Yes,
All right, just doing a test.
you're good.
Now, my little girl had a little wheelchair.
We got no paper.
What's it on for?
Not yet, we're going to. Yeah. No, we just, if we can get through this week, we've had so many courts. We had Monroe Court motion day on Thursday, and then we got this on Monday, and then we've got Cumberland County next, or this coming Thursday. So if we can get through that, then we're good. We just have to get the paperwork done. But yes, we are following. And Mr. What he's talking about, we didn't find any transporters because Judge doesn't want anybody transported. We haven't brought anybody. He sent one. Crashed it. We don't transport.
Our KCPC, we got two people, KCPC, they contact us back, and we take them.
I think they're really backed up.
Where did you guys do yours?
Yes, sir. Yes, sir. We'll get back behind
So then I came out and leave the car.
All rise. Commission Circuit Court now in session, the Honorable David Williams presiding. Make sure all your cell phones on stop. Bow your head for a long stop. Thank you, may be seated.
Dare County first.
Whichever one. We've got a bunch. Let me see who's on.
Are they?
Adair County's already on.
Okay, I'm gonna go to Adair County first. Adair County. Clinton Circuit Court, 21 CR 0025, Commonwealth, Kentucky versus Candy Ann Stuber and Jonathan Stuber, which is 21 CR 0024. Mr. Commonwealth Attorney, what do you have on these two cases?
Your Honor, they have Clinton County cases which have been pending for a while. And then they've also got a new felony case in Cumberland County, trafficking and controlled substance. That's the reason the court revoked the bond. And I'm going to ask for a trial date in Cumberland County Thursday on that trafficking case.
Okay, we'll continue this case here.
Your Honor, I did file a motion for bond relief.
Well, we can hear it.
It's
Okay.
not.
Notice for today. Go ahead then.
Judge, it's undisputed that they did pick up felony charges in Burkesville while they were out on bond. And then that's a bad place to start. But up until that point, they had done well. They did very well in home incarceration previous to that. They do have addiction issues. So I'm not, it would be akin to failing a drug screen. I don't think they got caught with a vast amount in Cumberland County. So I would ask the court to consider reinstating their bond potentially with home incarceration. And Cumberland County at this point is still holding them, so they would have to make bond in Cumberland County as well.
Your Honor, I would object to the bond being revoked here. These charges emanate from where there was a raid at their house and there was drugs in various rooms with various individuals there. It's been hard to pin it down on who had what. In the case on 10/1, October 1st of 21, both Mr. and Miss Stuber went in a car that contained meth while they were on bond for a felony case here in Clinton County. So I just ask that the bond remain revoked and they can get a speedy trial in Cumberland County if they want one. And we can go from there.
Clinton County trial. Why would you go to Cumberland County trial? Why not get Clinton County done? We've been in Clinton County for years.
I'd rather try one that I can convict you on, Mr. Stuber, and send you to prison if you want to know the honest truth.
Right. You have no conviction there either. And the money come out of the bank. You ain't got no case.
We'll
Jonathan,
find out. We'll
that's
see what
enough.
the jury says.
That's enough.
Well, let's
Maybe
say
he needs a Feretta hearing so he can represent himself. He's doing a good job.
Clinton County been going on since January. I think Clinton County should be tried first. You just wanna hold us on no bond here because you can't. That's just, it's the power trip for you.
John, that's enough.
We was going to school and anything, we was doing good. You want to try Clinton County, I don't know what I'm saying, so. I understand, it still makes no sense why I want to try Clinton County first, we've been doing Clinton County for over a year now. For almost a year now.
We'll try this one too.
Try it, man, I'm just saying, man.
John,
Mr. Stuber,
What have I done?
hey, Mr. Stuber,
Yes, sir.
you've said enough, okay?
I'm sorry.
Don't say,
I just want to know.
don't say anything else. Okay, we will address these cases. Can you be around Cumberland County? Will you be over, Mr. Sheffitt?
I think it'll probably work out that I'll be doing a case over there.
Your Honor, can we go ahead and set the Clinton County case for January the 10th, and we'll try it then. Mr. Stuber wants a trial, I'll give him one, and we'll give him one in Cumberland
Well,
County.
what I want to do is get the council over there and together with Mr. Sheffitt and just collectively talk about these cases here. And we can set the trial over here we can do that setting in
We can
Cumberland
get
County.
dates for both cases, and I'll give him a quick trial.
That way, the defense counsel will be there and you can be there and the officers, whatever. We'll see which one's ready to go first, okay?
Okay.
Okay, well, I'll schedule this then to be heard over in Cumberland County with the Cumberland County case. That would be this Thursday, isn't that correct?
Yes.
This Thursday. Okay, thank you very much. I don't think we have anything else in Adair County. Thank you for cooperation, Adair County.
I don't have a lot of the deals on.
What is ACRJ?
I didn't know, I just finished with them.
Okay, we have anybody at the Adair County Regional Center on?
That's who we just finished with.
Well, this was okay, that just had Adair County, so I didn't know that. Is there any other correctional institution on there ready to go except for Clinton County?
Yes, sir. You've got the Ross Cash Correctional Complex, Miss Charlotte Brown.
Ross Cash.
Okay, we'll call that next, so y'all don't have to be there.
Thank you, sir.
This is Clinton Circuit Court, case number 19 CR 0033. Commonwealth Kentucky versus Charlotte Lynn Brown. Are you Charlotte Lynn Brown?
Yes, Your Honor.
Okay, and Mr. Sheffitt, you represent her?
That's correct, Judge.
Okay, what do you have here?
Judge, this is a shock motion for Charla. She was revoked back in August after being terminated from drug court. I believe she made it into the second phase. Either Charla or the Commonwealth could correct me. She might have made it further than that.
I made it to phase 3.
Okay, she made it into phase 3. I thought that might have been the case, but her case before the parole board got flopped until November of next year. So we were waiting and hoping that she was going to make parole before bringing this before the court, but that did not happen. So she won't hear from the parole board again until November of next year. And I would ask the court, she's a local citizen. I think she would be perfectly capable of being successful on probation under the supervision of probation and parole. I'd ask the court to give her that opportunity.
Your Honor, she was final sentence on 12/2/2019. She was granted shock probation on March the 4th of 2020. She was revoked on her shock probation August 12th, 2021. So she's not eligible for shock probation again. That window period is closed. The court no longer has jurisdiction for shock probation.
I would disagree with that. Her probation was revoked in August of this year.
No, her shock probation was revoked, not her probation. Her shock.
I'd have to see a statute that distinguishes that.
Well, we can brief it. I've briefed it before, but you're not allowed to keep the window open more than 180 days for shock probation after final sentence. I mean, it's clear. I've got a brief at the office. I can show the court.
I disagree with that, because if somebody has their probation revoked 3 years or 4 years into the supervision period, I think the court still has 180 days from that point.
That's incorrect, because her probation was not revoked. Her shop probation was revoked. That's the key distinction. Court can enter whatever order it wants to, because corrections will recognize it, but that's what the law is.
You're not saying that the Department of Corrections would question one of my orders, are you?
No, I'd say they'll do whatever you want to, so they can release anybody. But if you properly
they
apply
always
the
do.
law, she's not
That's what they
eligible for
want
shop
to do.
probation.
Correction, so. Well, Mr. Shevit, you want to, I'll leave the situation open if you want to brief the thing. And I'll take a look at, see if she's eligible. I didn't really, it would appear to me that she's had a couple of bites of the apple already. So, and I don't know what, I'm shocked that they would flop anybody on any kind of drug charge.
Well, Your Honor,
You know what I mean?
My practice is for folks to wait unless their parole is so far off that it's beyond the shock period. Almost all of them come back that they get flopped. So I think there's a much higher percentage than what we realize, especially on first time. Parole
Okay,
opportunity.
well, I'll just, before next rule day, let's say, will 15 days be enough for you to brief that?
Yes, Judge.
And you can have 15 to respond, as long as we get it back.
We've dealt with this issue before. I can respond in a day, probably. So I've already got my brief done.
Give you 5 days after you receive his brief then. I don't believe you're right about this, Mr. Shevit, because we've handled some of them before, but we'll give you an opportunity to argue it, okay? Thank you so much. Okay, is there any other correctional institution on there?
We have Russell County on.
Russell County on? Russell County, are you on now? Russell County? Russell County Detention Center, turn your camera and microphone on. Could you give him a call?
The jailer just texted me and said he is working on getting on.
Okay. Let's go to Clinton County Jail. then. Clinton County Jail,
Yes, sir.
we have Billy Dean Eminette. Commonwealth of Kentucky versus Billy Dean Eminette, 21 CR 00085. Are you Billy Dean Eminette?
Yes, sir.
Okay, what's the Commonwealth have to say about this? Please.
You're muted, Jesse.
You take it in there.
I'm waiting to hear from his counsel, and I don't know who's representing him, because Mr. Cross contacted me about this case too, so I don't know who's representing Mr. Eminette.
Mr. Shefford, is this your client?
Yes, it is. I met with him last week. I got word from him at the jail that he either had been in contact or had hired Mr. Cross, but I don't have any confirmation of that.
Mr. Eminette, who is your attorney?
Mr. Cross.
He doesn't seem to be here. Mr. Eminette, they say you hadn't hired him.
Yeah, I talked to him on the phone. You can ask Kenny. I mean, I talked to him on the phone.
Well, back when I was practicing, when I was retained by someone, there was this issue called money. I don't understand why everybody interested in getting paid for their work. Did you give him any money?
Yes, I got $1,500 here to jail for him.
You ought to tell him that. He'll probably be down there about. You want to call it? We'll come back to you, Mr. Eminette. I'd say if you've got $1,500, you got a darn good chance of having a lawyer here in about 5 minutes. Bobby Joe Eminette. Bobby Joe Eminette. Yeah, this is Commonwealth Kentucky versus Bobby Joe Eminette. 19 CR 00050.
Yeah.
Okay, what do you got on this, Mr. Stockton?
I don't know if Mr. Cross mentioned Bobby or if that's Mr. Sheffield's case.
I don't know that he was, I don't know that it included Bobby. I just heard Billy. Bobby, are you represented by anybody else?
No,
Okay.
not that I know of. Not if Dave's gonna do me too. I don't know. Bill said
Okay.
something about it, but I don't know. I mean, can we keep it off another month, see what we do, or?
What do you got? What do you got, Mr. Stockton, on this?
Well, he's got one case, 19 CR 50, that we need to have a revocation hearing on. And then 20 CR 92, he's charged with criminal syndicate and possession of a forged instrument that we could get a trial date on.
Okay. Mr.
So I'm prepared to proceed with the revocation if we need to.
Okay. Have y'all had a negotiation day on this gentleman?
That's what I thought Sheffield
We
was
have.
saying.
Wait a second. We got a little out of hand about group participation here this morning. You know, this is, I want to be collegial with everybody, but if you got a lawyer, usually you let them talk for you. And that way you won't say anything. It'll hurt you. Understand what I'm saying? It's called a constitution.
And Judge, we actually got pretty far along with the negotiation. We were to the point where we were about a year apart, which included the revocation as part of it. Unless, when I left, I guess when I left Thursday, I haven't heard back from Bobby about any changes to my knowledge. So we're still kind of at that 1 year stalemate situation as of right now.
What was the last offer of the Commonwealth?
Your Honor, it was 2 years on the revocation, which is, it's a 2-year sentence, and 3 years on a criminal syndicate and possession of a forged instrument, and that could carry up to a B felony. And if he's rejecting that, I want to get a trial date. With
You
him
gonna
and his
run
brother.
concurrent or consecutive?
They have to be consecutive.
Okay.
So that's a big break in my understanding, going from a B felony to a D for 3 years. And if he doesn't want to take that, I want to get a trial date.
You want to run them separate, or?
Because we've been negotiating this case for 2 months.
And Mr. Eminette, what he's saying, to give you a total of 5 years to wrap both of them together.
Okay, I'll be doing time on both of them at the same time. Is that what I'm gonna be doing?
You'd be doing a total of 5 years. They're ending 2 years on one of them, 3 years on the other, but the total is just 5.
Okay.
So, do you want a chance? You want to
Can I
talk?
talk, can I talk to my lawyer, Brad?
Absolutely. We'll see you next month.
All right, thank you. My phone.
Josh Davis.
Mr. Stevens represents him, Your Honor, and he said he'd be running a little late. I think he cleared that with Ms. Thompson. He's coming from McCurry County.
Rodney Lee Duval. Are you Rodney Lee Duval?
Oh, I'm sorry, Your Honor, that was Mr. Davis.
Here, Rodney.
Commonwealth Kentucky versus Rodney Lee Duval, 16 CR 0023. Are you Rodney Lee Duval?
Yes, sir.
Okay,
Carson.
what do you- Mr. Stockton.
Your Honor, this is a 15 CR case, 5 years criminal mischief. We had Mr. Duval back in July. He had a failed drug test and we did an order in lieu of revocation. And now he's had his one or two positives for oxycodone.
Jesse, I thought we had an agreement for him to go to a long-term rehab.
Is that something you'll arrange?
We'll arrange it, and I've got an order. We need, the first step in arranging it is getting an order entered saying that which one he's gonna go to, and that'll move him up and get him there quicker.
I'll go along that if the court wants to, Your Honor.
I have a proposed agreed order for Jesse to sign and to present to the court.
Is it a 6 month? 6 month?
Yes, it's a Kentucky Recovery Center, which would be at 6 month. It's up in Erlanger. It's actually one that Rodney has been to before. He's familiar with it and he's done well there. And
I want to make sure that the order says that if he leaves there before successful completion of the program.
well, Judge, the order that I'm giving you would propose today only kind of gets him started on getting on the list. I will have to prepare a separate order that will actually get him released. And in that order, we can put that language in there.
I don't really care whether you do it with one order or two orders. I would have thought, however.
Because
Let me
we don't-
finish. Let me, wait, too many
Sorry,
people
Judge,
interrupted me today. Now, I've been, it's a beautiful day and Christmas is coming up, but I can get ill early and it'll be a long day for you, okay? So you give me the agreed order concerning, I guess, referring him there, and he's gonna stay in jail till then. I thought if you included everything in one order, if you got a bed early for him, he could go on, but if you don't want to do that, that's fine. Okay, who's next? Commonwealth versus Emmanuel Fluter. Commonwealth versus Emmanuel Fluter. Are you Emmanuel Fluter?
Yes, Your Honor.
Okay. Now, we got two cases here, 19 CR 0005 and 21-00099.
Your Honor, I would move. Oh, I'm sorry. I didn't mean to interrupt you.
Go ahead.
I couldn't hear. I would just move to combine those cases. One's just a superseding indictment on the assault. And I just move that they be combined and consolidated. And I'll prepare an order if there's no objection.
No objection.
Where are we? Do we have a trial date or anything in this case?
We need a trial date, probably a few months out, Your Honor. We got all the records from KCPC, so we're ready to get this case over with.
How far out do you gentlemen want to set this case?
I was thinking April sometime, if that was all right, April or May. We probably need, depending on whether the masks are still in effect, we'd probably need at least 3 days, I think. Several witnesses.
How about April the 11th?
That's fine with me, Your Honor.
That's fine. The one exception, the one issue that we would possibly have is Ms. Hunter's in court in another county today. I'm not sure if that would be some type of conflict for her. If it is, we'll bring it to the court's attention as soon as we can.
Okey doke. 11th, now do y'all want a pre-trial in March or something?
That'd be fine, Your Honor. Any motions need to be filed, but then I think all the motions have been filed, that I can think of.
Yeah, any motion would be. Now, I believe I changed the venue of that over to Cumberland County, and I think the Commonwealth wanted to be heard on that again. Is that correct? Did you want to rehear?
That's correct. I'll file a motion based on the Huber case out of Northern Kentucky.
Okay, probably be good if you file that a couple of months beforehand.
I'll file it by February then.
But that'd be good by the February rule day, and that way y'all can prepare for that. So do that. Okay, thank you very much. Commonwealth versus Sherman Hensley.
I believe that's also Mr. Stevenson's case, if I'm correct.
Okay. Commonwealth versus Tim Harold. Tim Harold. Are you Tim Harold?
Yes, sir.
This is 21 CR 00115. Commonwealth versus Tim Harold. What does the Commonwealth have to say?
It's an arraignment, Your Honor.
Mr. Harold, we're here for the purpose of arraignment. You have a right to remain silent. Your attorney is here on the record. What is your date of birth, sir?
Age 1285,
And the last four digits of your social security number?
0095.
The grand jury of Clinton County has returned an indictment charging you possession of a handgun by convicted felon, 2 counts, it appears, and possession of a controlled substance in the first degree, methamphetamine, and trafficking controlled substance in the first degree. Do you understand those charges?
Yes.
Counselor, do you acknowledge the identity of your client? And I'm going to send the indictment back. You waive formal reading and arraignment, enter a plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay. Okay, I'm signing a reciprocal discovery order here. Signing a reciprocal discovery order. What is next month? You want to be back here for a pretrial on January the 13th?
Your Honor, what is Mr. Harold's bond?
It's $20,000 surety.
Yes, sir. Person signed though.
You say 13th.
We're all still in court.
See you on January 13th.
I think there's a negotiation.
Is there, what is the negotiation day?
December 20th.
December the 22nd at 9 a.m.
December the 22nd at 9 a.m. and then on January the 13th. Both part of the bond conditions.
They know what the hell I'm testing.
Who is that? Ricky Dwayne Jones? Ricky Dwayne Jones. Oh.
We have to do, I'm sorry, Your Honor.
Commonwealth, Kentucky versus Ricky Dwayne Jones. 21 CR 0032 and 21 CR 00108. Are you Ricky Dwayne Jones?
Sir.
Okay, did you have something, Mr. Stockton?
Yes, we were notified this morning that he accepted the offer we made. So we have to do paperwork and have it sent to the jail. And we're shorthanded, so it may be a little while.
His attorney, sir, would you identify yourself for the record? Okay, wait just a second. I can't understand. If you just lower it just for a second.
My name is Danielle Brown. I am standing in for Ms. Hill. This morning, I'm standing still from the DA office. She had another report this morning. I spoke with Mr. Jones regarding the offer with the Commonwealth. It's my understanding that he wants to take it.
Okay, well, they'll get the paperwork done if you'll just stay around for a while,
Yes,
okay?
sir. Thank you.
Okay. Mr. Jones, they'll get the paperwork over to you. Your attorney says she's gonna be able to stay here and get that done for you, okay?
Your Honor, would you want to take up Mr. Leverage's case, Chris Thrasher, and then we'll start working on some of the.
Yeah, I wasn't aware that he had a case.
Well,
Yeah.
that's if we get Russell County. That was the issue.
So we didn't have Russell County Jail on there was the issue.
Oh, okay.
Till we do, then let's do Rodney Manus.
Russell County.
Okay,
Your Honor, Russell County is on.
okay, well, we'll go to the special case then. Is it, where is it? Commonwealth Kentucky versus Chris Thrasher. If you want to, the public defender will allow you to use the Zoom back there.
Yes, sir.
Okay, Commonwealth Kentucky versus Chris Thrasher. Are you Chris Thrasher?
Yes, I am.
What's your age?
39.
Okay, and what are the last 4 digits of your social security number?
140.
Say that again, please.
2940.
Is there anyone else in the room there? Can you drop your mask just for the second? Thank you very much. We're here for a pretrial conference. What do you have to report, Mr. Leverage?
Judge, we've got a pretrial on one case and there was an indictment returned on the second. I was not 100% sure if the arraignment was on for today as well.
Yeah, we can do that. That's 21 CR 00114. And Mr. Thrasher has already identified himself. Mr. Thrasher, we're going to add the arraignment here in this case. You have a right to remain silent. The grand jury of Clinton County has returned an indictment charging you with wait a second. With 152 counts of possession material portraying a sexual performance by a minor under 12 years of age. You understand that charge, sir?
Yes, I do.
Okay. Counselor, do you acknowledge the identity of your client, waive formal reading arraignment, enter a plea not guilty, reserving all pretrial motions?
Yes, Your Honor.
I'll send those indictments back to you. Could you pull those indictments? That is in 114. Take those back up there. Now, Mr. Stockton, since you have these new charges, do you want to put this over for, well, I said Mr. Stockton. Mr. Leverage, since you have these new charges, you want to put this over for a month or?
If we
2
could,
months?
maybe January, Judge, if we could put both cases on, that will give me an opportunity to get with Mr. Ousley about the discovery, send him what we can, and then make sure that he's got access to the things that we're not able to copy.
Okay, let's set this for January the 13th. And Mr. Ousley, I tell you what, you go ahead and make direct contact with the Commonwealth Attorney's Office. And if y'all have any discovery problems, then we can schedule a phone conference or anything like that. If it's, I don't think, I never have had any problems with Mr. Stockton or Mr. Leverage as far as providing open discovery.
And we'll do the same thing here, Judge. We will make photocopies and send them to Mr. Ousley of everything that we can. Because of the nature of some of the discovery in the new case, we can't copy it, but Greg will be able to come to our office or something like that at his convenience and take a look at the other.
Okay, well, I will, you want to schedule, if he's going to do that, y'all just schedule your own negotiation day and I will not formalize that, okay?
That's great, Judge. Thank you.
Back here on January 13th. Thank you
Judge,
very
that's all I've got. Can I be excused?
much. Absolutely. Have a great day.
Thank you,
Your
sir.
Honor, may I address the court?
Sure. About this case?
Yes, Your Honor.
Okay, well, I already excused him. I'm glad you did it quickly.
Thank you, Your Honor. I was just going to ask the court to review the bond. I believe it's $500,000. We were going to request that the court make it 100,000 cash or property.
What's the Commonwealth's position?
Judge, I think in my estimation, the indictment speaks for itself. There are 152 counts of 2 counts of distribution and 150 counts of possession of child pornography. My fear is that with Mr. Thrasher's resources, he would be a flight risk if he were released. So I believe the bond is proper where it's set.
Mr. Ousley, I will not use this as your allowed one bond reduction hearing. You just brought it up, so, you know, I'm going to allow you not to burn that bond reduction up. Well, if you want to get some evidence together and that sort of thing, and we can hear that on the 13th.
Thank you, Your Honor.
Okay, thank you very much.
Thank you, Judge.
Yeah. While we're at Russell County, let's just finish out there. Commonwealth of Kentucky versus Jeremy Van Winkle. Jeremy Van Winkle.
Yes, sir.
This is 17 CR 0021. Commonwealth of Kentucky versus Jeremy Van Winkle. Mr. Stockton, what do you have here?
It's Mr. Sheffield's motion for shock.
Mr. Sheffett?
That's correct. Mr. Van Winkle, his probation was revoked in August of this year, and his parole was flopped until November of next year as well. He did get pretty far along into drug court. The termination of drug court was the grounds for revocation, and I believe he got into phase 3 and close to aftercare before he was eventually terminated from the program. And he's been in since August and won't have another opportunity to be released by DOC until November of next year. So there's no Jeremy can do well under probation and parole. He has the tools that he learned in drug court. If he will put those.
What was he revoked out of drug court for?
Your Honor, he had a 5-year sentence on burglary third, and he served 5 months on that sentence. He went into drug court. He did really well. He was at Sun Pools. And then for some reason, he and Charlotte Brown, I don't know if they were married at the time or just lived together, But they both absconded from drug court at the same time after they were doing good. They had some positive drug tests. They did a little well, and then they absconded again. Now, we've had Mr. Van Winkle in court in Cumberland County. I think he was tried down there on a theft case, if you recall, over some barn lumber. And then we gave him opportunity to go to court, drug court, and then he just absconds. And I don't understand why he would do that. But if you abscond, I'm not going to be for shock probation. You know, you get tired as Commonwealth attorney and police officers chasing people. You just do after a while.
Do you have anything else to say in response to that, Mr. Shutter?
Jeremy, would you like to address the court?
I don't really know what to say. It's gonna help anything. I would like another chance to be out.
Is this, he didn't get much of a sentence in Cumberland County, did he? What did he get?
I think a jury found him guilty of a misdemeanor, I believe.
Yeah.
Felony cases down there.
1 year or something, okay. Well, there seems to be a continued pattern of thievery in here, and I'm just gonna go along with the parole board. I'm gonna deny this motion for shock probation. I hope you turn your life around. Okay, is there any, let's go back to the beginning of Russell County. Amy Angel. Amy Angel. Commonwealth versus Amy Angel, 21 CR 00037. Are you Amy Angel?
Yes.
Okay, we're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes.
Is it substantially correct?
Yes.
Counselor, is there any reason why this lady should not be sentenced today?
Your Honor, she has conflict counsel. I'm trying to look up and see who that is. If she could advise the court.
Who is your attorney, ma'am?
Candace Hill.
The Glasgow office.
I apologize, I was unaware that this case was on, but I'm not aware of any reason to go forward with something today.
Could you identify yourself?
My name is Danielle Brown from the Glasgow DPA office, filling in Ms. Hill this morning.
Okay, thank you very much. Upon a plea of guilty to trafficking in a controlled substance first degree, the defendant shall receive a sentence of 7.5 years, probated for 5 years. She shall enter and complete a long-term rehab facility determined by probation and parole. The defendant shall remain in custody until a bed date is available. She shall receive credit for the time served. What is the court cost? $155. I'll allow you to start paying that 30 days after your release from the long-term rehab. The defendant shall remain in active supervision until the court costs have been paid. There's no restitution, is there, Mr. Stockton?
Not that I'm aware of. No.
After, it just had restitution in the order, so.
Yes.
Okay. After final sentencing and the conclusion of all co-defendants, the defendant agrees to have all contraband destroyed. And she also forfeits any claim or any interest in any money or all bills involved in the case. Okay? Now, probation and parole will be in contact with you. And as soon as the bed date is open, we'll sign an order, move you there, okay?
Thank Thank you.
Alternative sentence, giving.
Yeah, that'd be wonderful. Thank you. Commonwealth of Kentucky versus Johnson, Barbara.
Barbara Johnson.
Barbara Johnson,
Backwards on
okay.
the docket for some
It's
reason.
backwards on the docket, which is apropos for today. You're here, are you Barbara Johnson?
Yes, sir.
You're here today for the purpose of arraignment. What are the last four digits of your social security number
7842,
and your year of birth?
11490.
Finish that.
The grand jury of Cumberland County, are you represented by the Office of Public Advocacy?
That's correct, Judge.
The grand jury of Clinton County has returned an indictment charging you with traffic and controlled substance first degree, convicted felon in possession of a handgun, possession of controlled substance first degree, and possession of drugs unspecified. You understand those charges?
Yes.
We lost it. Wow. Counselor, do you acknowledge the identity of your client? And I'm going to send the indictments back there. Waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
Sign a reciprocal discovery order. And certain discovery will be provided to you. You want to set this case for a pretrial on January the 13th?
Yes, Your Honor. And negotiation day on the 22nd.
22nd for negotiation. 22nd of December. What's this? What's Ms. Johnson's bond situation? Pretrial.
She's 20. Yeah, she's $20,000 surety on this case.
Does she have other holders?
Did you all get it? $20,000.
Yeah, does she have other holders? Does she have anybody else holding her from anywhere else?
She does. Warren County's holding her. And she.
You're fading out on us pretty badly. She's got a holder out of Warren County and from where else?
Yeah, she's a state inmate in Warren County.
Okay,
His
that's all I
holder.
need to know, so I won't worry about that. Commonwealth versus Nick Posey. Commonwealth versus Nick Posey. P1CR 00104. Are you Nick Posey?
Yes, Your Honor. Yes, sir.
What's your year of birth?
6/17/81,
Last four digits of your social security number.
5606.
Here for a pretrial conference. What does the Commonwealth have to say?
Your Honor, we have a proposed felony plea.
Judge, let's make sure that Russell County, do y'all have a copy in the file, in the court file? I sent it to Russell and they were supposed to send it back to the clerk's office. I just want to make sure that occurred.
Bill Bell said that he was sending it back. I'm not 100% sure, but I can check with him when I get done here. We did receive it.
We have it here.
Okay.
Mr. Posey, a motion has been tendered that says you wish to enter a plea of guilty today. Is that correct?
Yes, Your Honor. Yeah. Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given? Is this plea, okay, you need to speak up a little bit, please,
All right.
okay?
All right.
Okay, are you the same person named in indictment number 21 CR 00104?
Yes, Your Honor.
Is your judgment impaired to any today? Is your judgment impaired today?
Yes, Your Honor. Yeah.
No, okay. That means, do you know what's going on today?
Yeah.
Are you aware if it's impaired, you would not understand what's going on today, okay?
Yeah.
So you know what's going on?
Yeah.
Do you understand the charges? Do you understand the charges against you today?
Yes.
It's Amber Alert. Has anybody threatened or coerced you in any way to get you to enter a plea?
No. No, sir.
Have you had plenty of time to discuss this matter with your attorney? Are you fully informed about your case?
Yes.
You understand that you do not have to plead guilty. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea of guilty, I need to know that you fully understand these rights. Yeah. You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, the right to be represented by counsel, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses, your favorite process issue to compel their attendance. You have a right to appeal this matter to a higher court if you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty of charges against you. By entering a guilty plea today, you give up all those rights. Now, do you understand that?
Yes, Your Honor. Yeah.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence allowed by law. I do not have to accept the recommendation. Prior to accepting the recommendation, I will await the pre-sentence investigation report from probation parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, I will reject the plea, but prior to making that decision, I'll have that pre-sentence investigation report available to you for your review. Mr. Stockton, could you go ahead and read the agreement?
Yes, Your Honor. Mr. Posey would plead guilty to possession of controlled substance first degree, receive a sentence of 1 year to serve. The Commonwealth would oppose probation and shock probation that would run consecutively with Clinton Circuit Court 14 CR 43. The possession of a handgun by a convicted felon would be dismissed. There was another person involved at the scene, and the Commonwealth doesn't believe that it would prevail on that charge if tried. So that's the reason for the dismissal on that.
Is that what you agreed to, Mr. Posey?
Yes, Your Honor. Yes, sir.
Okay. Are you pleading guilty because you are guilty and for no other reason?
Yes.
Okay. Now I'm going to have a pre-sentence investigation report. Are you a state inmate now?
Yeah. Yes, Your Honor.
Waive that, but I do want to tell you that because of this plea today, this could be used against you in the future to enhance a sentence in any felony in the future under persistent felony offender law. Do you understand that?
Yes. Yes, Your Honor. Yeah.
Okay. Well, I will accept the plea. And is this your signature on this document here? You sign this document?
Yes, Your Honor. Yeah.
Make sure we got the right document. You can see it there, correct?
Yes. Yeah, I see. It's correct.
Signature. Okay. Well, I'll go ahead and enter the judgment then today. Okay.
And so, Judge, you're agreeing to waive separate sentencing?
Yes, I am. Since you state inmate. Commonwealth versus Jennifer Stockton. This finishes at the Russell County Jail. Commonwealth versus Jennifer Stockton, 21 CR 00044. Are you Jennifer Stockton?
Yes, sir.
Okay.
Yes, sir.
You're here today on a pre-trial conference. What is your year of birth?
1976,
Last four digits of your social security number.
5538.
Mr. Commonwealth Attorney, what do you have in this case?
Based on my conversations with Ms. Jones, I believe we need a trial date, Sean. This case was previously set for trial.
I can use the,
When Mr. Shefford had Ms. Stockton and he withdrew because of a conflict and Ms. Jones took over.
I guess there's no reason for.
Oh, Nick Carter's got it.
Counselor, just come on back out here and we can do it out here, okay? Oh, she's there now, okay. You're all right there now, okay? Okay, did you hear the Commonwealth say that it's time to set a trial date?
Yes, sir. I was going to ask Mr. Stockton to reiterate his offer to the defendant.
Did you state your offer, Mr. Stockton?
No, no. Shh. Hold on just a second. My offer was 15 years with a C felony on trafficking and a PFO first, which would make her parole eligible after 10 years to the board. And I've got two different cases with substantial amounts of meth. And so I would try 21 CR 44 first and then try the other case subsequent to that if that offer is not accepted.
Now, what is the amount of sentence that might possibly she be?
Well, my understanding is with a C felony and a PFO first, you can get up to 70 years would be the maximum sentence.
When would I be, what is the percentage was my question.
Well, if you accept the offer, you would not be parole eligible until you've served 10 years. And that's based on your criminal history, because this is about the fourth time I think you've been in front of me, Ms. Stockton. I think you've been in prison 3 previous times. So, and then we've got the two cases and they're both.
What about the 15 years? How does that, I'm not understanding that. Okay, if I want to do, I would probably take 10 at 85.
I can't do that under the statute. I can't do that. All I can do.
I mean, the doing the 10, then going up for the parole, that's, I mean.
Well, all I can do is enhance it to C with a PFO first, and that makes it 10 flat. I can't do it 85% at 10. I'm just not allowed to do that.
But I still have to do the 15-year sentence when I'm done with the PFO.
Never had a day like today.
Well, you just need to talk to your lawyer. That's my offer. And I guess we need to trial that.
She couldn't answer my questions.
I'll return and clarify matters with her.
Hey, I'm going to continue this to the 13th, Mr. Stockton. If we set a trial today, it wouldn't be different when we said.
No, that's fine, Your Honor.
So she seems to want to talk to her attorney again. So we'll continue this to the 13th of January. Commonwealth versus William Purdue. Okay. Commonwealth versus William Purdue.
Just a second, Your Honor. I'm sorry, I didn't have him on my list. I'll go get him. Be just a minute.
Commonwealth versus William Purdue, 21 CR 00109. Are you William Purdue? Okay, we're here for a pretrial conference today. Mr. Shuffett, your attorney, is there. We'll go to Harlan County next. Harlan County, would you turn your camera off and then we'll be right with you, okay? Thank you. Mr. Stockton, what do you have here on William Purdue?
Your Honor, on 15 CR3, that's a motion to revoke. It's a 12-year sentence. 21 CR 109. My understanding, Mr. Purdue will do a misdemeanor plea and that he will stipulate revocation on 15 CR3.
Is that correct, Mr. Shuffett?
Yes, Your Honor, that's correct.
A motion's been tendered, sir, Mr. Purdue, that says you wish to enter a guilty plea on a misdemeanor charge. And what is the misdemeanor on possession of controlled substance? Is that what it is? A misdemeanor
Second
plea?
degree, yes.
Second degree. Is your judgment impaired today? Okay, you have certain constitutional rights that you have. And you have a right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses, the right to produce evidence, the right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove on a reasonable doubt that you're guilty of the charges against you. By entering a guilty plea here today, you give up those rights. Now, this is not an enhanceable case. Is that correct, Mr. Stockton?
No, the misdemeanor would not be.
Not enhanceable. So you are entering this guilty plea because you are guilty and for no other reason? Is that correct?
Yes.
Okay, I'll go ahead and sign the judgment in this case and the revocation. Are these consecutive or?
By statute, it'll run concurrently, so he'll have the 12-year sentence to serve.
Okay, thank you very much. Okay, I'll enter order today. I'm gonna take a short break to go wait on the grand jury. I'll be right back up here. Make sure you know that that's all. Harlan County. Harlan County, this is Commonwealth of Kentucky versus Trenton Tucker, 21 CR 007 and 20 CR 0030. Are you Trenton D. Tucker?
Yes, sir.
What's your year of birth, Mr. Tucker?
3/21/1995,
And the last four digits of your social security number?
6299.
Okay, Mr. Stockton, what do you have in this case?
I believe this is Mr. Shuffett's motion for shock, Your Honor.
Judge, that's right. Trenton took a 5-year sentence back in June. And we waited as long as we possibly could, waiting to hear back from the pro board before we filed for shock. He was flopped until January of 2023. So, you know, it'd be another 12 months before he'd have a chance to be released. Trenton is a Wayne County resident. He's at Harlan County, is just he's participating in the SAP program at Harlan County. And I'd ask the court to consider maybe allowing him to complete the SAP program and then releasing him on shock probation.
Mr. Stockton.
Your Honor, the Commonwealth would inform the court that Mr. Tucker had a fleeing and evading first charge along with assault third. When he was in the Clinton County Jail, he threw a coffee pot and hit one of the deputy jailers in the chest with it. We settled the case for 5 years and I dismissed a PFO second, but I believe that that's an appropriate sentence and he should have to serve it. And the pro board must agree with me.
Yeah, I just inciting a riot and assault on the officer and fleeing and evading in a motor vehicle are not sort of things that we take lightly. I think he got a very good deal in the last situation. I'm going to deny the motion for shock probation. Hope things turn around for you. Okay, does that finish us in Harlan County? Thank you very much, Harlan County, for your cooperation. We go back to Clinton County Jail.
We got Wayne on.
Wayne, Wayne is on? Wayne County. Okay, Leslie County. Is Leslie County on there? Okay, we'll go to Wayne County. We'll go to Ashley Barton. Commonwealth versus Ashley Barton, 19 CR 0061.
Your Honor, go ahead.
Thank you. Are you Ashley Barton?
Yes, sir.
Born in 1987?
Yes.
What are the last four digits of your social security number?
2957.
Okay.
Your Honor, this is her shock motion.
Okay. Go ahead.
She has a 7.5-year sentence and she's not pro eligible until July of this year. This is one where her probation was revoked earlier this year. And she did violate the terms of her probation. We didn't necessarily argue that, but I think there were some extenuating circumstances. She had mental health issues that really stood in her way. She was doing very well, maybe as well as she's ever done there for a period of time, holding down jobs and completing programs, staying sober. During the pandemic, she was unable to treat her mental health as it needs to be treated. And that led to a backslide that led to her revocation. And I'd ask the court to probate her. I think, she did very well on probation for a period of time. And I think so long as she takes care of her mental health, I think she can do very well on it again.
Mr. Stockton?
Your Honor, she has a 7.5 year sentence for trafficking. She was sentenced February the 6th of 2020. She was shot on 5/6 of 2020, shock probated. Her shock probation was revoked on 9/9/21 because she absconded. Again, she's another person that's not eligible for shock probation because the time period is running.
We'll just include her on the brief. We'll accept it. Thank you very much. Lay it over, subject to the briefing schedule. Commonwealth versus Benjamin Clavel.
Benji's not in here right now. There's just a few of us that's in here.
Okay, I'll go down through and see if I can catch who's there. Crystal Crabtree. Commonwealth versus Crystal Crabtree. 19 CR 0020. Are you Crystal Crabtree?
Yes, sir.
Okay, you're here on a probation revocation hearing, it says here. What does the Commonwealth have in this case?
She has a 5-year sentence on receiving stolen property. She was terminated from drug court. It's my understanding she's going to stipulate.
That's correct, Judge.
Okay, well, I will revoke and sign the order then. Thank you very much. James David Denny. This is Commonwealth of Kentucky versus James David Denny, 15 CR 00112, a probation revocation hearing. Mr. Stockton, what do you have?
Your Honor, I would need to call Miss Anderson. I believe Mr. Denny has a 12-year sentence, and it's a motion to revoke his probation or his shock probation.
15-year sentence.
15-year, okay.
You may proceed.
I'd ask Miss Anderson needs to be sworn in, I believe.
Officer, would you raise your right hand? You swear the testimony you're about to give is the truth, the whole truth, nothing but the truth.
Yes, Your Honor.
Okay, go ahead.
Miss Anderson, have you been supervising Mr. Denny?
I have.
And how long have you been supervising him?
Since January, roughly around January 9th of 2020.
Okay. And recently, has he had probation violations regarding new arrests and absconding probation?
Yes, recently he has had new violations concerning that.
Could you tell the court what those are?
Yes. Let's see. On November, I'll go back to the absconding portion and then I'll tell you about the new charge. That way you get the time frame on that.
That's fine.
On October 18th, he was released from the Wayne County Detention Center and directed to report to Lake Cumberland Recovery in Burnside for treatment. And he did arrive as directed, but on October 28th, when I spoke to him by phone, he wanted to know about getting out of that placement and going to another placement. He had a couple in mind that he thought he would like better. He didn't like where he was. And I explained to him that that's not how that process can work. He can't go to a treatment facility and then decide he doesn't like that and check himself out and go to another one. So then on November 1st, I received an email from the center director at Lake Cumberland Recovery, and they advised that he had left the facility on 10/29, and he had failed to contact me at that time. So that's when we did the absconder warrant on that. So then on November 27th of 2021, he was arrested and lodged in the Wayne County Detention Center after receiving the wanton endangerment 2nd degree of police officer, the fleeing, evading police 1st degree, speeding, and reckless driving.
Okay. And he's been lodged since that time?
Yes.
And he was, I take it, he was in the treatment approximately 8 days before he left?
Let's see.
The
18th to the 29th.
Okay, I miscalculated, about 11 days. Then he evidently he had previous violations, the reason you were sending him to the rehab facility. Is that correct?
He did have previous violations of drug use.
Okay. I don't have any other questions. Your Honor.
Ms. Anderson, you said that you began supervising him in January of 20th. Was he supervised by another officer prior to that?
He was granted the shock probation out of Clinton County, and Officer Carson Payne had supervised him for a short period of time before sending me the transfer because he lived in Wayne County. So living in Wayne County, I would need to supervise him since I'm the supervising officer in that county.
Okay. And was he compliant for, I guess, how far was he compliant? I know there must have been some setback in order for him to get to rehab, but
When he, prior to coming to me, when he was with Officer Payne, I have no mention of violations. But once he came to me on July 16th of 2021, we did a drug test in the office and he was positive for methamphetamine. He denied use when we sent it to the lab and it came back a positive. So we set him up with the SSC and he was to follow all recommendations regarding treatment. So prior to starting IOP, he was supposed to go to a detox program. So he went to the detox program, and then when he was discharged from the detox program is when he stated that he had COVID. So I did the whole, once you're released from quarantine from COVID, then you can come and see me and we'll talk about it. Then we'll give you a new SSC appointment and we'll go from there. And that's kind of when he started not reporting the changes. We did a home visit. He didn't report how he was doing out of quarantine. Once I did make contact with him and he came to the office, he stated that if I drug tested him, he would be positive for methamphetamine and he wanted treatment. So going forward, that's when we got him into Lake Cumberland Recovery in Burnside, and he left that facility on his own.
I've got no further questions.
Just to clarify, Your Honor, I'll be brief. It appears that on September the 21st of 21, he was positive for the use of methamphetamine. Is that correct?
Yes.
And also on October the 11th of 2021, he admitted to the use of meth.
Yes, that's when he came to the office after we did the home visit and made contact. He said that if we were to drug test him, he would be positive for methamphetamine.
Then he was also on October the 11th positive for the use of alcohol.
Yes, he
Or
also
admitted
admitted
to
that. Yes.
admitted to that. Okay. I have no further questions.
Hey, do you have any witnesses to call, Mr. Shepard?
Your Honor, I'm reluctant to call Mr. Denny simply because he has pending charges in Pulaski County.
Wayne County.
Wayne County. So I'd like to just at this time make argument.
Okay, go ahead.
And Your Honor, I understand he's got new charges. I don't know how far along those have progressed at this point. Mr. Denny has been an addict for a long time and at times has done very well with treatment and with sobriety, and other times has fallen off the wagon. And this appears, this period of his life appears to be a time where he fell off the wagon a bit over the last several months. I'd ask the court to allow him to serve a sanction period and then allow him to be released into long-term rehab.
Mr. Stockton.
Your Honor, based on all the allegations and violations described by Mr. Anderson, including the new felony arrest of fleeing and evading, and absconding, I'd ask that he be revoked.
Yeah, the failure to conform and the assaults that originally were underlying here, and then absconding, I'll make him not a good candidate for continued release. So I'm going to revoke his probation. Next case is Joey Duval.
Your Honor, that's all I have. May I be excused?
Sure, thank you so much.
Thank you.
Joey Duval, 19 CR 0. Are you Joey Duval?
Yes, sir.
Were you born in 1980?
Yes, sir.
Last four digits, social security number 6376.
Yes, sir.
Okay, Mr. Stockton.
This is Mr. Shefford's motion for shock probation.
Shefford.
Your Honor, Joey's probation was revoked earlier this year, I believe in September. And he's not pro eligible until well into next year. Joey was in Ohio and being supervised in Ohio when the violations that led to his probation revocation occurred. And Joey went up there with the best of intentions. His wife / fiance was from Ohio, and he went up there with the best of intentions. I think once he got there, it turned out it probably wasn't what he was hoping for as far as just stability and resources. And he really struggled to meet even minimal living standards. And while he was up there, he's got a great deal more support and resources here in Clinton County. He has served a good period of time here, looking at least 3 or 4 months since revocation. I'd ask the court to allow him to be released. Now, he does have an addiction issue, and if probation and parole, the court or the Commonwealth believes he needs to go to a long-term rehab before he starts in on his probation, I think that would be a good idea, and Joey would welcome that.
Mr. Stockton?
Your Honor, he meets the parole board April of 22. He has a 5-year sentence. He was transferred to Ohio at his request. The probation was transferred. He received multiple criminal charges in Ohio, mainly shoplifting and theft. Then he returned to Kentucky without permission. And I think they found him hiding out in some abandoned place. I've dealt with Mr. Duval for several years. He's just never complied with anything. If the court thinks long-term treatment would help him, I don't think he's eligible for drug court. I think he's already been in drug court. So he's about at the end of his rope. People can either get out and work and be contributing members of society, or they can continue to use drugs and steal, and I have to deal with them. And it's their choice. I can't choose for them. So I'll do whatever the court wants to do, but he certainly doesn't have a good track record.
Mr. Sheffett?
Well, Your Honor, obviously, we're asking that the court allow him that chance out on probation.
I know, but yeah, everybody wants a chance, and I believe in first and second chances and things like that. Does he have a plan that he's going to do? He's got his hand up there.
I think he does have a plan. If we could allow him to speak.
Yes, I do have a plan. Right now, my mother is sick. She has 3 months to live. I plan on spending the most time with her as I can. I'll also be working for Lester Wallace and helping my dad until I can gain a better employment, which I also want to put in at Tyson's Chickens. So I do have a plan here. I just want to spend the last moments with my mother that I can. If there's any way you can find it, then that's fine. Because I'm really asking you for, I really need it. I would do any type of IOP program or any type of rehab program that you would like for me to do.
I thought he was wanting to go long-term treatment.
Yes.
Mr. Sheffett proposed.
Yes, I do.
Like a minimum 6-month treatment away from him.
Yes.
How long has it been since you've seen your mother?
It's been 3 months now.
Okay. Well, I'm going to go with the long-term treatment here. And what I'll do is allow an agreed upon member of the family to take him to the long-term treatment. Mr. Stockton?
Yes.
I would like to see if he can offer a member of the family it would be acceptable to pick him up to transport him to the long-term treatment.
Pandora Duval, my
That'd be
stepmother.
fine, Your Honor.
Okay. Well, she can pick you up, and what I'm going to allow you to do is let her pick you up and come down and visit with your mama.
Thank you.
Before you go. Okay. Now, everybody gets a break sometime in their life, and all of us who've lost our mothers, we feel empty for it. But I've had people lie to me about whether they're going to turn around and use things for an excuse. So I'm going to let you come down and have a reasonable visit, maybe 3 or 4 hours with your mother, and then you go to the long-term thing. If I have any more problems, If the Commonwealth attorney ever calls me and says you've let him down and us down, the court system down, don't ask for anything else.
Okay,
Okay?
totally understand.
Okay, thank you very much.
Thank you all.
April Payton. April Payton. Are you April Payton? Are you April Payton?
Yes.
Okay, this is 21 CR 00103. Ms. Payton, you're here today for sentencing. What are the last four digits of your social security number?
1870.
And what's your year of birth?
Your Honor, can I interrupt just a moment?
Sure.
On the sentence, and I hate to do this, but she has a co-defendant, Joseph Payton, who's not entered a plea yet. And the reason I granted her deal was because he's supposed to enter a plea. And if he doesn't enter a plea, I'm going to object to the sentencing in this and ask for a trial date on both of them. And I'd like to take up Joseph Payton before we take her up, because he's got a 10-year sentence to serve. I don't want him backing out.
Is he in jail over there? Let's just go to him.
Yeah, he's right here, Judge.
Joseph Payton. Joseph Payton, Commonwealth versus Joseph Payton, 21 CR 00102. Are you Joseph Payton?
Yes, I am.
You born in 1976.
Yep.
Last four digits of your social security number, 8810.
Yep.
Okay, I understand that you wish to enter a plea. Is that correct?
Yes, Your Honor.
Are you currently under the influence of drugs or alcohol?
No, I'm not.
Is this plea freely and voluntarily given?
Yep.
Have you had plenty of time to discuss this matter with your attorney and review the evidence? You feel like you're fully informed, and are you satisfied with his representation?
Yep.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and the United States Constitution. Before I can accept a plea of guilty, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. The right to speed trial by jury, the right to be represented by counsel at jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to a higher court if you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. By entering a plea today, you give up all those rights. And I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept any recommendation. Prior to accepting any recommendation, I will await the pre-sentence investigation report from probation and parole. In the event that I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, I will notify you that I reject the plea, and if I sentence you a harsher sentence, if you don't agree with that, you have a right to withdraw your agreement. You understand that?
Yes, Your Honor.
Okay, Mr. Stockton, will you go over the plea agreement?
Yes, Your Honor. Mr. Payton will plead guilty to trafficking in a controlled substance, first degree heroin. He will receive a sentence of 5 years. He'll also plead guilty to trafficking in a controlled substance, first degree methamphetamine, a sentence of 10 years. Those two sentences shall run concurrently for a total of 10 years to serve. The Commonwealth opposes probation and shock probation. He'll receive credit for time served, pay court costs at discretion of the court.
Is that what you agreed to, sir?
Yes, Your Honor.
Are you pleading guilty because you are guilty and for no other reasons?
Yes, Your Honor.
Realize that these pleas could be used against you in the future if you have any additional felonies under persistent felony offender law. You understand that?
Yes, I do.
What are the court costs on this thing? $155 court cost. I order a pre-sentence investigation report done by probation and parole. You can be here on January 13th for sentencing. And you acknowledge in open court that was your signature on the agreement. Is that correct?
Yes, I do.
Okay. Order PSI and see you on the 13th. Thank you.
Judge.
Yes.
On Mr. Payton's case, I did notice a motion of return of property. There were a number of things seized at the time of his arrest that we believe are of a non-evidentiary nature. The ashes of a deceased loved one that essentially Joseph and April were kind of living out of their car. So they had a lot of belongings in the car. that.
Well, why don't you meet with the Commonwealth, and if you can agree with that, that's fine. And if there's something that is an issue before it's destroyed, I'll give you an opportunity to make a presentation on
If he'll
January.
just submit an agreed order, I think we can agree on everything.
Okay, and if you can't, bring anything on the 13th that you can't agree upon, okay?
Okay, thank you.
Okay, let's go back to April Payton now. Now, Mr. Payton, you previously identified yourself in 21 CR 00130. We're here today for sentencing. Have you had an opportunity to look at pre-sentence investigation report done with probation and parole? Ma'am, have you seen the pre-sentence investigation report done with probation and parole? Have you seen that?
Yes, sir.
Is it substantially correct?
Yes, sir.
Counselor, is there any reason why this lady should not be sentenced?
No, Your Honor.
On a plea of guilty to fleeing or evading police first on foot, she shall receive a sentence of 5 years. On a plea of guilty to traffic and controlled substance first degree meth, she shall receive a sentence of 5 years. The two 5-year sentences, however, shall run concurrently for a total of 5 years. Serve 117 days in jail with a balance probated for 5 years supervised. She shall receive credit for time served and shall be released at final sentencing. The defendant shall, what's the court cost in this thing? You what? $155. You need some time to pay that, ma'am?
Yes, sir.
Okay, I'll let you pay it $30 a month,
Okay,
starting 30 days from today.
okay, thank you.
Okay.
And Your Honor, I have the same motion for Miss Payton. There were some clothing, some other items that.
Hey,
she
well,
would
y'all,
like to
you know,
return.
present an agreed order and I'll sign it. If there's anything you can't agree on, you can consult with Ms. Payton and she come back into court on January 13th to testify that, okay? Thank you very much. Jonathan Ray.
Judge, I'll have to bring him in a minute after him and Benji, after you get these other two females done.
Okay, that'll be fine. I don't know what other females that we've got. Could you tell us who's there?
They already brought me up, but they said,
What's your name?
Ashley Barton.
Ashley Barton said you was going to review her.
No, that's a brief. We're going to review her on a brief, Mr. York. She's already.
Okay. All right, I'll bring Benji and Jonathan Ray in here.
Okay, thank you. Could you see if you get a hold of Leslie County Jail?
I can try.
Okay, and the other one, in Pulaski County. Pulaski.
Which one you want first, Judge?
Benjamin Clable would be fine. Commonwealth versus Benjamin Clable, 21 CR 0088 and 21 CR 0089. Are you Benjamin Clable?
Yes, sir.
You born in 1986?
Yes, sir.
Last 4 digits of social security number or what?
24 or 29, 24, 15.
I think it's 2415. Could that be it?
No, it's 29, 24, 15.
Well, that's not enough numbers. So give me your whole social security number.
406, 29, 24, 15.
Okay, so the last four digits are 2415.
Yes, sir.
Okay. What do you have, Mr. Stockton?
We're too far apart, Your Honor. We need a trial date.
Okay.
Jesse, which indictment? It was 88.
Part of 89. We'll get to that in a minute.
Let's go out into April. And check out April 25th.
That's fine with me, Your Honor.
That's fine, Judge.
What was the Commonwealth's offer?
I think it's 25 years. He came back at 3. Your Honor, I would elect to try 21 CR 89, the portion of the charges that include convicted possession of a handgun by a convicted felon. My understanding is I can't try that case along with the trafficking charges because you have to show he's a convicted felon. So I would try the portion that the handgun by a convicted felon first. It's a C felony.
That's on the 18th?
That's on 21 CR 89.
No, I'm talking about the day. Was the day the 18th?
No, April 25th.
25th, okay.
Yes.
I had to flip over and I lost it there.
We'll prepare an order just so there won't be any confusion.
Okay,
I've tried the whole case.
On the
Mr. Sheffield doesn't.
I'll set it on the 25th and 26th, and I'll give you to the January rule day to make a definite election between.
Okay.
Okay.
If Mr. Sheffield wants to try the whole case, I will. If not, I'll bifurcate.
Okay. That'll be fine. And I guess y'all can set a pretrial on it on March 3rd, I guess. Make that on February the 11th, pretrial, February 11th. Okay, Jonathan Ray. Jonathan Ray. Commonwealth versus Jonathan Ray, 21 CR 0083. And 21 CR 00105. Are you Jonathan Ray?
Yes, sir.
What do we have going on here, Mr. Stockton?
I have a proposed felony plea, Your Honor.
Is that correct, Mr. Sheffield?
That's correct, Judge.
Okay, Mr. Ray, a motion has been tendered that says you wish to enter a plea in this case. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in this indictment?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you reviewed the case the Commonwealth has against you, the evidence? Had plenty of time to discuss this with your lawyer, and are you satisfied with his advice?
Yes, sir.
Okay, there are certain constitutional rights under the Kentucky United States Constitution that I need to know you understand before I can allow you to enter a plea. You have a right not to testify against anyone. No one can make you say anything. You have a right to speed trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you. You You have the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court. If you lose, you have the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty. Now, by entering guilty plea today, you give up all those rights. Now, I may consider the Commonwealth's recommendation, but I may impose any sentence that is allowed by law, even though it be harsher. If it's harsher, then I'll allow you to withdraw your plea. But before I make that decision, I'll review a pre-sentence investigation report done by probation and parole. Now, listen very carefully to see if this is what you agree with, Mr. Stockton. Mr. Stockton, you're off. Mr. Stockton, your
I thought I clicked it and it didn't click. Okay. On 21 CR 83, Mr. Ray will plead guilty to operating a motor vehicle while license suspended or revoked before driving under the influence. That'll be a sentence of 2 years. Also in 21 CR 83, he'll plead guilty to possession of controlled substance first degree, be a sentence of 1 year. Also in that case, he'll plead guilty to failure to maintain insurance. That'll be a $500 fine. Also in 21 CR 83, he'll plead guilty to DUI, operating a motor vehicle, fourth offense. That'll be a sentence of 5 years. All those sentences shall run consecutively for a total of 8 years. In 21 CR 105, he'll plead guilty to tampering with a prisoner monitor device, receive a sentence of 5 years. The 5 year and 8 year sentence shall run concurrently for a total of 8 years. He will serve 180 days in jail, be probated for 5 years, supervised. He will enter and complete the Clinton County Specialty Program, pay court costs of discretion of court, obtain and maintain gainful employment, and all contraband in this case be destroyed.
Is that what you agreed to, sir?
Yes, sir.
You realize that these felony pleas and the DUI fee are both enhanceable. It means if you get another felony, you could receive more time the next time. And on the DUI, it will be a more serious charge if you get another DUI. Do you understand that?
Yes, sir.
Anyone forced or threatened or coerced you to enter this plea, or you entered a plea because you are guilty?
Yes, sir.
Okay, has he been evaluated for drug court yet? Specialty court?
There's been an order entered. I don't know if the evaluation has occurred.
Well, has he got his days in?
We think he's real close.
Okay, well, I will await an agreed order on the number of days, and we'll sign an order, release him to the drug court for orientation when that happens. Is that you did sign this motion, you acknowledge in open court that you signed this agreement, is that correct?
Yes, sir.
Okay, I will accept your plea and order pre-sentence investigation report to be done by probation and parole. I guess he'll have to be held, won't he, Mr. Stockton, until that's received at the sentencing?
I would think he need to be held with sentencing, and Mr. Cross did not mention assessing him in drug court this morning. Has he assessed you, Mr. Ray?
No, I hadn't. I've been trying to contact my lawyer and him, and I ain't been able to get a hold of Harry about getting it.
Harry Cross is? Yeah. We'll get Mr. Cross down there as quick as we can.
Okay, January the 13th will be this sentencing day, and then we'll take, hopefully something can be done about the drug court before then. Okay, thank you very much.
Do I got to stay in here until January 13th?
Yeah, you'll have to stay there till you get evaluated and the pre-sentence investigation for today.
All right.
Okay, thank you very much.
Thank you.
Yeah.
I think that's all we've got for you today, Judge.
Okay, well, thank you very much for wait just a second. Thank you very much for your cooperation, and happy New Year, Merry Christmas to y'all, okay?
Same to you all.
Yeah.
So I've had another officer in Grizzly County and Pulaski County. She keeps getting a runaround. They just keep transferring her call. She's not having any luck getting home. Grizzly and Pulaski.
Let somebody answer the phone there.
Yeah, whenever she talks to them, they just transfer.
Give me the Leslie County number.
But yeah, it's down there.
You're on, Mr. Stockton.
All right, just a second. I'll get to it.
Just give those two numbers to the sheriff downstairs. Just give those two numbers to the sheriff on Leslie and Pulaski. And I'll and write the number here on front of each one of those and see if you can call them. Sometimes that helps. Okay, let's go. We got a Cumberland County case here
She's in person.
in person. We'll wait for that. So we're ready to go to out of custody.
No. We've got Clayton County jail. We didn't finish.
Didn't finish with Clinton County. Okay, let's go back to Clinton County. Was on Hensley.
We need to start with Billy Emmett.
What?
We need to start with Billy Emmett. It's our first one.
Okay. Let's go back to Mr. Amonette.
And he has been retained.
Okay, thank you very much. I thought it might. And it had eggs with it too. Yeah, okay. Commonwealth of Kentucky versus Billy Dean Amonette. All right, Mr. Amonette, are you on there? Your attorney?
Yes, ma'am.
Retained counsel, Mr. Cross is here. We're here today for a pretrial conference. What do you have, Mr. Cross?
Your Honor, I preliminarily called Mr. Stockton last week, so we might be getting in case he and I just need to sit down. I'm going to digest the entire thing.
What's the negotiation? 22nd? 22nd of December negotiation date, and the next court date is January 13th. Okay. Okay, he'll be in touch with you, Mr. Amonette. Josh Davis. Commonwealth versus Josh Davis. 21 CR 0040. Are you Josh Davis?
Yes, sir.
I need those.
I spoke to the Commonwealth. We received a written offer, I believe, for my charges. I was going to possibly.
Yeah. There's no problem. We'll set this thing to be heard in Cumberland County on Thursday. So that way, Mr. Davis, your attorney, will be back in contact with you with the written offer so you can look at it more closely, okay?
Oh, when did you say Thursday?
Thursday, that's just Thursday.
I'll talk to you today, though.
He'll come down and talk to you today, all right?
Okay, thank you, sir.
Okay, yeah, Sherman Hensley.
I may just let.
I think still waiting on a evaluation.
Are you Sherman Hensley?
Yes, I am.
Okay, Mr. Stockton.
We're waiting on KCPC to arrange evaluation.
Okay, let's continue it to January 13th then. Okay.
Thank you.
Yeah, I'll see Thursday, no problem. Ricky Jones. Ricky Jones.
Well, I won't do the election, but I only want to do the trafficking.
Ricky Jones.
Convicted possession of a handgun. I'm going to try that one charge.
Mr. Stockton, you're on.
Okay, thank you.
Yeah. Commonwealth versus Ricky Dwayne Jones. 21 CR 0032 and 21 CR 00108. Where is Mr. Jones? Are you Ricky Jones? Are you Ricky Jones?
Yes, sir.
Okay. Okay, what do you have on his case, Mr. Stockton?
We've prepared paperwork. I don't know if it's made it to the jail yet or not. It's been signed.
Have you received a plea agreement down there, Mr. Jones?
Yes, sir.
Have you signed it?
Yes, sir. I have one question.
Well, wait just a second. You need to talk to your lawyer.
I talked to her earlier.
Okay.
Simple.
What is your question then?
My mother's got surgery coming up on her neck. I asked her, well, actually, I told her I'd sign the plea agreement if she could, get me out. And she told me, yeah. All right, look, as long as.
Well, if it's not in the plea agreement.
Oh, yeah. Well,
Wait just a second, sir. If it's not in the plea agreement, it's not in the plea agreement. Now, if you don't want to enter a plea, that's fine. But I can't be doing adjustments to the plea agreement because that is an agreement between the Commonwealth and your attorney. Now, Mr. Stockton, have you heard anything about this surgery?
No, I hadn't. And, Your Honor, he has 2 possession charges. He was out on bond when he got the other possession charge, so his bond was revoked. The plea basically says 5-year sentence to be pretrial diverted, 2.5 on each, and then he would enter and complete drug court. Usually they get out when they are oriented for drug court, and that would be I wouldn't want to deviate from that policy because that's what we always do.
Okay. Here's the deal, Mr. Jones. If these are pretrial diverted, you're going to get out as soon as you can be oriented into drug court. Did they vote on him in drug court today?
No, he's not entered his plea yet, so we actually enter the drug court order today for him to be assessed.
Yeah. And then
so he's looking at probably 30 days.
He had to be voted on probably on January 13th.
Yeah, that's probably when he would get out.
Yeah.
Well, no, he wouldn't get out until the assessment was done, or until orientation schedule. He'd get out morning.
He get the day the orientation happened is when he would get out. So it might be a little while after that.
Yeah.
So
if he doesn't want to do that, I guess we can get a trial date on the second possession case, the most recent one.
Can we set the first one for trial too?
Here.
May I clarify and call over?
You need to speak up.
Sorry. May I call over and clarify something with my client and see what they're doing?
I'm sorry,
Let me tell you what, your lawyer is going to contact you. If you get 2 pretrial diversions and you can walk away from this with nothing, you don't need to be trying a case. I'm not telling you anything. There's something wrong with your decision-making process here.
No, sir.
She's going to call you and talk to you about it, and we'll come back to the case. Okay, Rodney Manis. I feel like Monty Hall today, Rodney Manis. That'll soon be like when I used to talk to people about Perry Mason. Nobody will remember Monty Hall pretty soon. So, Rodney, are you Rodney Manis?
Yes, sir.
Okay, 21 CR 00020. Okay, what do you have, Mr. Stockton?
Your Honor, we have an agreement, but it was only made today, and there's going to have to be an information indictment done. If you want to do it Thursday, I don't have any objection. Give us time to do the paperwork.
Okay, well, to wrap it all up and do an information, Mr. Shefford, is it okay with you to take it over to Thursday and get the paper signed that way and everything?
That's my request, Your Honor.
Okay, that's what we'll do, Mr. Manis. We'll get you back on TV on Thursday from Burkesville. Okay.
Okay. Thank you.
Thank you. Robert Lee Smith.
Robert.
Commonwealth versus Robert Lee Smith, 21 CR 00072. Are you Robert Lee Smith?
Yes, sir.
Born in 1972? You born in 1972?
Yes.
Okay. What are the last 4 digits of your social security number?
3749.
Okay, you're here today for sentencing. Do you understand that?
Yes, sir.
Have you had an opportunity to review the pre-sentence investigation report done by probation and parole?
Yes, sir.
You find it to be substantially correct.
Yes, sir.
Counselor, is there anything that would keep this gentleman from being sentenced?
Carson.
Carson.
Do you have a copy of that PSI? I can't find one.
There's no reason not to be sentenced today, Judge.
Thank you very much. A plea of guilty to possession of controlled substance first degree. The defendant shall receive methamphetamine. The defendant shall receive 3 years. On the other charge, the other one is first degree, first offense, 5 years, for a total of 8 years consecutive. Defendant agrees to forfeit the Remington rifle, 9mm, 22 caliber ammo to Kentucky State Police Post. Now, both of these charges, Mr. Stockton, were under the same indictment number. Is that correct? Mr. Stockton? Mr. Stockton?
I'm trying to bring order back here, Your Honor, so I can talk and get all these conversations out of the way. So
Bring them back here. I'll get them. I'll take care of them for you.
okay. Now, yes, Your Honor, go ahead.
So both of these charges were on the same indictment number, the 3 year and the 5 years, correct?
That's correct, Your Honor.
Okay, so I'll go ahead and enter the judgment. And the sentence is complete. Thank you very much. Now we got Donovan Waller. Donovan Waller. Donovan Waller.
Yes, sir.
This is 21 CR 0023. Mr. Stockton, what do you have on Donovan Waller?
It's a motion to revoke, Your Honor. He has a 5-year sentence on trafficking. He was placed in the drug court and he was terminated from drug court. My understanding is he's going to stipulate.
Well, what was the reason he was terminated from drug court?
I think he absconded, but I'll have to check the file.
I think that's correct, Jesse.
Yeah.
Okay, well, I will go ahead and enter the revocation. And, serve the sentence. Ricky Joe Wright. Ricky Joe Wright. Are you Ricky Joe Wright?
Yes, sir.
Okay. We're here in case number 21 CR 00015 on a probation revocation hearing. What's the Commonwealth have?
Your Honor, he has a 7.5-year sentence on trafficking controlled substance. He served some time on it. He has 3 violations. He was referred to Adonta. He didn't go. He had a positive test and a diluted specimen on the test. I was going to propose he either go to long-term treatment or proceed with the revocation.
Mr. Shepard?
Your Honor, we would be open to long-term treatment or drug court, either one.
I just believe he need long-term treatment. And if he has anything else, we can put him in drug court myself, but I would prefer that.
Okay, I'll do an order, a normal order with 6 months, and if he gets out or leaves without completing, you need to report to the Clinton County Jail.
You want that through probation parole, or you want to find him a place, Mr. Sheffield?
I would prefer probation and pro. I think they can probably do it quicker.
Okay.
Okay, Randall Dickin. We'll have to come back to Joe.
He'll live here in town too.
Commonwealth Kentucky versus Randall Dickin, 21 CR 0062. Dickin.
Sir?
We're here on a revocation hearing.
No.
We're on a revocation hearing. Is that right, Mr. Stockton?
Yes, sir.
Okay, would you go ahead, please?
I'd call Mr. Payne in this case, Your Honor.
Is there any hope that they would stipulate to this, or?
I don't know. It's, he used methamphetamine. He was positive for that. I thought he absconded too.
Well, we got him picked up. That was one.
You need to sit down in front of the camera there, Mr. Stockton. We can't see.
Okay. For some reason, I'm not finding my notes on him. If you'll give me just a second.
Okay.
I must have skipped him. Oh, I make notes too. So. Your Honor, he was, on September 13th, he verbally admitted use of methamphetamine. And then on September the 20th, the probation patrol attempted to locate him. He didn't report, so he was listed as absconding.
Okay. We got some kind of radio feedback in the background that needs to stop. Is that at the jail?
Yeah.
What's the second?
Okay, what do you have to say, Mr. Sheffield, about this?
Your Honor, this situation where we don't necessarily dispute the allegations as much as we disagree with the Commonwealth as to what the court should do. I believe that a sanction
that's right,
and allow Mr. Dickin out back on probation would be appropriate. He does have still dealing with some pretty serious medical issues, has a hernia that's given him a lot of trouble over the last several months.
Was he under a curfew previously?
I don't think so, Your Honor. And also, and basically he had those violations. Then he had a new test on November the 17th for methamphetamines. So I don't know, maybe drug court or long-term treatment might be the appropriate resolution in this case. He might do drug court.
Well, if he's got a medical issue, I don't want to take him away from the area and his doctor. So I'll sign a drug court referral for him. And as soon as that gets in place, they'll try to get him oriented and everything. So it'll be a few days, and the time between now and then will serve as sanction time and not good time, okay? Yeah, I'm gonna go to Leslie County. Where is this? Somebody bring me that paper back for Leslie County. Mr. Stockton, you have a copy of the Leslie County case. I sent my copy down to the sheriff's office.
Bobby Phillips.
Bobby Phillips, Commonwealth versus Bobby Phillips. This is Commonwealth versus Bobby Phillips. 21 CR 00110. Are you Bobby Phillips?
Yes, Your Honor.
You're here today in Clinton Circuit Court. Mr. Stockton, what do you have in this case?
This is an arraignment, Your Honor, on a assault first case, and he is a state prisoner.
Okay, Mr. Phillips, this is an arraignment. Your attorney, Mr. Sheffield, is on the line here. You have the right to remain silent. I suggest that you exercise that right. The grand jury of Monroe County has returned an indictment charging you with assault of first degree, possession of a firearm by a convicted felon, and being a persistent felony offender in those two charges. You understand those charges?
Yes, Your Honor.
Mr. Sheffield, I'm sending the indictments back to you. You acknowledge the identity of your client. Waive formal reading of the indictments. acknowledge accepting the indictments, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay, January the 13th. We'll be back here, okay? Thank you very much, Leslie County, for your cooperation.
Thank you, Your Honor.
Hope you all have a Merry Christmas.
You too.
Pulaski County, is Pulaski on there yet?
No.
Okay, we'll hold
Your Hon-
Pulaski.
Your Honor,
Yes,
on that case, I don't want to keep Mr. Smith in jail any longer. That was Commonwealth's motion to revoke, and he was charged with a new felony, but that case was never presented to the grand jury, so I'm going to withdraw my motion to revoke in that if the court wants to release the holder on him, on Richard Smith. He's in Pulaski County.
so you're withdrawing your motion to revoke?
Yeah, it was based on a new felony arrest, and that case never went to the grand jury, and I declined prosecution on it, so I'm asking.
It went to the grand jury today.
It did?
I have reason to believe that it did.
It probably shouldn't have, but that's okay. We'll
Okay,
deal
well,
with it. We'll deal with it next month.
Okay, so you want to still just hold in abeyance this revocation in case there's something you don't know about?
Yes.
We'll pass the revocation to January the 13th. Is he being held on something else?
I don't believe so.
He will. He will be soon,
Well, he'll be held pretty soon on something else. While,
He's got a pen here as an alternative sentence.
okay, well, why don't you, when we get off these things, maybe you can have somebody in your office call to see who was with the grand jury today, and we'll just pass this case over to next month till we find out something, okay?
That's fine if me and Mr. Sheffield.
We don't have anything done with Mr. Jones yet. He's still down there deciding whether he wants to get out of jail or spend jail in Christmas and subject himself to 5 years in the penitentiary. So when he decides whether he wants to do that or not, we'll call his case back. So let's go to the out of custody cases. Let's take care of this Cumberland County case. If you could open the door and yell for Sierra Parrish.
Judge, are you finished with me?
No, I'm not finished.
Okay.
We got all these out of custody people. I don't know. Just monitor us. We'll try not to be too hard on you.
Okay.
Sierra Parrish, 20 CR 0036, a Cumberland Circuit Court case to be heard here today. Mr. Stockton, what do you have about this? Sentencing, is that correct?
It's a sentence, and Mr. Judd or Mr. Carter can handle it while I'm packing up, moving out.
Okay. Have you had, Ms. Parrish, have you had an opportunity to look at this report, pre-sentence investigation report? Is it substantially correct? Is there any reason, counsel, why this lady should not be sentenced today?
No, Your Honor, she did want me to point out that in the pre-sentence investigation report, the Commonwealth's offer is a little bit incorrect. There's one provision that was in there that was not actually in the Commonwealth's offer that the court was reviewing. So that was her only concern with the pre-sentencing investigation report. Everything else in there is correct.
She has no problem with the plea that was entered, though.
No problem with the plea.
Okay, upon a plea of guilty to trafficking in controlled substance method, the defendant shall receive a sentence of 5 years, probated for 5 years. Shall serve an additional 90 days of home incarceration. Probation is to be supervised. She agrees to forfeit 2005 and doesn't matter to me. Want to pay 155 off or you want to pay? Okay, make your first payment to Cumberland County Circuit Clerk's Office 30 days from today. You need to meet with probation parole officer. I guess, do you know, if you've been interviewed by probation parole, you call them immediately after court and make arrangements to meet them as soon as possible. He's got a card for you right over there, okay? There you go. Thank you very much. Okay, let's head down through the list of out of custody people. Albertson, let's 5 or 6, 7. Tony Albertson. Commonwealth versus Tony Albertson, 21 CR 004. You, Tony Albertson, here for a pretrial conference today. Have any resolution of this?
Your Honor, it's kind of falls with get this evaluation completed. We're going to have to go another route. We're not going to be able to do outpatient. So probably won't have to actually go to case. That's not good.
I can't understand that. Anything.
Judge, he's telling me.
You back over this way, back over that way. I'm gonna have to pull your mask down so I can hear you.
He's telling me he's got an appointment with the folks in Lexington. The folks in Lexington, it's been a few weeks since I talked to them. They told me that wasn't the case, but I believe we probably have.
What is the appointment up there?
He's saying January 4th.
Mr. Stockton, you believe that if he's got an appointment up there on January 4th, I guess they're farming some of these out now. Okay.
I would say the February motion day, we should have something.
February the 11th, you be back here. You make your appointment up there in Lexington, that place, and be back here February 11th. Okay. Okay, be back here February 11th. Okay, thank you very much. Stay out of trouble. Merry Christmas. Sherry Sue Barnes.
Is she back in the hospital? Okay, she called this morning, Trey talked to her, see she was out, but she might have gone back.
Somebody in the hallway told everybody with that. What's that?
Will issue a bench warrant for her, subject to recall. Get Mr. Cross. Mr. Cross, I'm issuing a bench warrant for her, subject to recall if y'all provide proof. Well, just give me some proof on it and I'll call it back. I don't think the likelihood of sheriff going up there tonight and getting her is not great, probably. And that's also 21 CR 0048. Have a tendency to think anybody that's in the hospital now is probably sick because it's hard to get in the hospital. Brandy Beatty. Commonwealth versus Brandy Beatty, 21 CR 0018. Are you Brandy Beatty? Are you Brandy Beatty? Okay. You're here today for a sentencing. Do you understand that? Have you had an opportunity to go over your pre-sentence investigation for probation parole? Is it substantially correct?
Yes, it's last time.
Credit for time service, pay court costs and now what? $155. You need some time for that. Let you pay it $30 a month. The first payment 30 days from today. Okay. There's no restitution in this case. you agree to have any and all contraband, other substances disposed of the law. Is that correct? Okay, you need to meet with the probation parole officer right over there. Okay, thank you. Caleb Brown. Is it still morning? Commonwealth of Kentucky versus Caleb Brown. Are you Caleb Brown? It's 21 CR 00112. We're here today for the purpose of arraignment. You're represented by retained counsel. You have the right to remain silent. Have questions from your attorney to your attorney, step away from the podium. Okay, grand jury of Clinton County is returned an indictment charging of burglary in the 3rd degree, criminal mischief, indecent exposure. Disorderly conduct and stalking in the 2nd degree. You enter a plea of not guilty on his behalf. Waive formal reading and arraignment, acknowledge receipt of indictment, reserving all pretrial motions. Yeah, I'm signing reciprocal discovery order. Mr. Stockton, have you looked at this case here?
I have reviewed the case, but I have not reviewed the video. It's a fact.
There's a video of this activity.
Yeah, it's pretty explicit.
Well, what is the bond in this case?
It's $20,000 cash.
He's made that bond. What kind of restriction do they have on it?
2 times property, trial monitoring, 24-hour curfew, except work, medical appointments, religious services in court, no contact with victim, all other standard conditions.
Is there just one victim, Mr. Stockton, allegedly?
Yes, it's a business that owns that and the lady that's been there running the business.
Okay, well, let's name the business in the bond.
It's South End Jewelry Store. Courtney Roberts owns it. I can't think the name of the place. It's a name Jake South.
What's the name of the store out there? What? Okay, put Courtney's Jewelry and the alleged victim's name in the bond too, okay? Okay, we'll give you that off when we're offline, okay? Okay.
I just asked John, there have been complaints about him driving by a bit before. He don't even need to be out there in vehicle.
Let me tell you something. There are a lot of places in this world that you can go and not go to jail. I find you out there around that business, around this woman in any way, you'll be in the system for a while. No use terrorizing anybody. I'm not saying you did this, but evidently she believes you did. And she's, you know, that's not good to be around them. I wouldn't even go that into town. You understand what I'm saying? I won't hear you. Do you understand what I'm saying? Okay, we'll see you back here on January the 13th. Yeah. 22nd of December is negotiation date. You have to be here on that day and back here on July the 13th too, okay? Thank you. William David Cope.
Also have this in his house.
Commonwealth of Kentucky versus William David Cope, 21 CR 0070. We're here for a pretrial. What you got in this case?
This will still set for trial.
It's set for trial, I believe, on January the 10th, along with another case. There's a code in it, Mr. Code, and then there's a separate set of cases. What else?
Yeah, I'll be ready to try one of them off here, Mr. Shepherd.
I'm really having an attack of conscience, so I'd really like to try Mr. Stevens that day, but he thinks I'm mistreating him, so I feel bad about that. I could try him.
I'll say this, Mr. Stephen, the case with the Stevenses are set on the 10th. The
Yeah.
court set on the 11th.
That's right.
Judge, if it's possible, I would prefer to try one. I hate to try two cases exactly, not exactly the same, but very similar. We're talking about tenant issues, back-to-back days, in front of the same jury.
Well, I could disqualify the jurors that sit on that case if you'd like.
Well, I would sure request that.
Okay, well, we'll do that. So that's set on the 10th, is it?
No, the 11th
The 11th.
for this one.
Now, it's been brought to my attention that the surety on your bond wants to come off. Signed document here. Mr. Brian Connor. That's what it says. Do what? Well, I don't know about that. I'm not doubting that, but I'm just saying what this says here. I don't know why it wants to come off of it. So you're in custody, but you'll need to find somebody else to go on your bond.
I'm taking care of my mother now. This was the last 2 months.
Mr. Stockton, do you have any objection to ROR? You don't think he's a flight risk, do you? I'm gonna change your bond to ROR. If you disappoint us and go against it, that NCIC, they used to say they'd send a dog after somebody, but
I've been here.
okay, I know, yeah, that's the reason you get a break. Okay. Hope your mother does better, man. Okay. Commonwealth versus Jeffrey Paul Hunley.
No, he changed his bond. So, yeah.
You're a Jeffrey Paul Hunley. Correct. What do you have in this case, Mr. Stockton?
It's our motion to domesticate Willis. He's, the check's written on a out-of-state bank, and I'm just asking for a court order so we can get the state of Tennessee to issue a subpoena to the record.
And is this scheduled for trial?
The 20th, scheduled, but it's only in Berkshire. I just need the subpoena for Berkshire.
No, we just discussed that.
Yeah, I'm all right now, please. Let me, I'm saying there was some kind of conflict on this. See.
You did not.
You see what I'm saying? Right there. is that? Okay, well, give me the order and I'll sign it.
Your Honor.
It's in that email. I didn't pull it up.
Okay, if you'll step over this way, if you'll get behind the microphone, okay? I can't hear you, I'm sorry.
This is a 2000, Your Honor, I sent a request for bill of particulars for 2018 incident. I wanted the entire account. What they got me for instance in 2019. And the other thing is apparently there's some sort of video court proceeding here and Clinton circuit court pertains to this. And they're going to furnish it to me. All this being said, I think it'd be appropriate, Your Honor, to pass this, to take this off the trial docket for Monday and send it back for.
What kind of video is it?
It's a video where Mr. Hunley was involved in another suit, and he's given a description of all these things he's done about hiding assets and not having any money and everything, and I think that goes to his intent as far as not paying Mr. Travis ultimately over the approach.
Were you were involved in
It
that?
was a post-judgment deposition.
Yes, but.
You were involved in that?
No, that was the Anthony Wilson case, and I had a conflict, I wasn't involved.
That's what it is. That's the video. And it's.
Well, today is just Monday.
And they, we're gonna make it on the clerk's office by the way, get it made on that page.
Well, it needs, what clerk's office, the one here, needs to be made today and in his hands today.
Yeah.
If it's not in his hands by the close of business today, I'll give him a continuance.
Fair
Okay. See y'all on Monday. Rocky Allen Machino. Okay, let's put Rocky in NCIC, okay?
Judge, his case, he was in drug court, he was medically terminated from drug court, he come and see me, and I went ahead and started his transfer to Tennessee. This was just a motion to put him back on, that he can be actively supervised by probation department.
So you said we ought to pass over, is what you're saying?
I don't know, I was just telling you what's going on.
Where, is Mr. Stockton handling this or?
But I think from what little I know,
His transfer is pending right now in Tennessee.
I just need to order or something so we get that paid. Talk to somebody about that.
Rocky Allen Machino.
It's a motion so he can be placed on supervision. He doesn't qualify for drug court because of medical.
You just have an order that you want to submit. We withdraw that bench warrant. Rocky Allen Machino, that's the next one on him. Kenny Joe Mason. Commonwealth Kentucky versus Kenny Joe Mason. Are you Kenny Joe Mason?
Sir.
What's your year of birth?
1874,
Last four digits, social security number.
3776.
Okay, y'all have an agreement on this case? Okay. A motion's been tendered, says you wish to enter a plea today. Just hold it there. I'll tell you what, just hold it there. A motion's been tendered, says you wish to enter a guilty plea today. Is that correct? Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given? You're the same person named in indictment number 21 CR 0067. Have you had plenty of time to review the evidence in this case, and are you satisfied with your attorney?
Yes, sir.
Okay, I understand that you wish to ask the court to enter a pretrial diversion order for you. Is that correct? Have you still need to be aware of your constitutional rights under the Constitution of Kentucky and the United States of America. You have a right not to testify against yourself. No one can make you say anything. You have a right to speak trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to a higher court if you lose, and the right to acquire a Commonwealth proven on a reasonable doubt that you are guilty of charges against you. You understand by entering the plea today, you give up those rights. Okay, now a pretrial diversion means that if you successfully complete the terms of pretrial diversion, your case will be dismissed pretrial diverted. However, if you violate the terms of pretrial diversion, which you've agreed to, be brought back into court, and I revoke the pretrial diversion, have a pre-sentence investigation report done by probation, parole, and be sentenced, then you'll be a convicted felon. You understand that? If that happens to you, then those felony convictions could be used in the future to enhance sentences if you have other felonies. So you understand that? Have you had a pretrial diversion within the last 10 years? Have you been convicted of a felony? Okay. Okay. Is there any reason this gentleman should not be qualified for pretrial diversion, Mr. Stockton? Okay. Well, I'll sign the pretrial diversion agreement. That is your signature on there?
Yes.
Okay. We'll need to meet with the probation and parole officer right there. What is? Give this to Mr. Stockton, allow him to sign. There's a restitution order. You want to read through the pretrial diversion agreement, Mr. Stockton?
Just put it on the record, Judge.
Yes. You move over to the right and let Mr. Carter do this.
Your Honor, I'm gonna plead guilty to theft by unlawful taking under 10,000, defendant will receive a sentence of 5 years pre-trial diverted for 5. Paper restitution in amount of $717 jointly and severally with co-defendants Chad Scott and Roger Scott at the monthly rate of $100. First payment due within 30 days of the entry of this plea and on the same day of each month, subject to a 5% clerk fee. No contact with the victim or the victim's family or real property. Defendant will receive credit for time served, pay fine and costs at your discretion, and obtain gainful employment of 30 hours community service until employment is obtained. Remain on active supervision until all fines and costs are paid. All evidence will be disposed of.
Is that what you agreed to? Get that copy back to Mr. Stockton. Okay, well, I'll go ahead and accept that. Excuse me. We have accept that and you meet with the probation parole officer there, okay? Okay, here's all the document right there. Date that name. Cecil Nevels. You know what? Thank you. Cecil Nevels.
Jeremy Barkley on behalf of Mr. Nevels.
Good to see you. This is 21 CR 0094. We're here for a pretrial conference. What is your year of birth, sir?
07/11/1996.
The last 4 digits are social security number.
4543.
Okay, what does the Commonwealth have to say in this case?
Your Honor, we're closed on this. We have one more pre-trial, which the trial's over in our plea in January.
January the 13th. Do you want the negotiation date or?
We don't think it's wrong.
Okay, January the 13th, you return, okay?
That's all I have.
Have a safe journey. Merry Christmas.
Merry Christmas to you, Your Honor.
Yeah, Jesse Phillips. Jesse Phillips. Commonwealth versus Jesse Phillips. 21 CR 0017. Are you Jesse Phillips? You're on a pretrial. Y'all want to move over this way a little bit?
Your Honor, when we had the last pre-trial negotiation day, I've got Mr. Lagos in there, and there was range found on Mr. Phillips. That's the person that wasn't sent out for testing because it was this range. So I either need to have it sent out for testing or amend this back to district court and drug paraphernalia charge. So I thought he was going to take a plea. But it's not going to.
What was the offer?
Well, it was 2 years, previous 2 years probation, 2 years a day probation, 5 years, I think was the last option we wanted to do.
Well, that's offer actually 12 months on the confession.
Well, evidently he's not taking the plea.
Hold on, you're right, I apologize.
I can't understand anything you said.
Your Honor, I apologize. In the possession of drug paraphernalia?
Yes.
Okay, I misunderstood the offer.
Okay.
Your Honor, can I have a minute, please?
Can you have what?
Can I have a minute to speak with my client, please?
Yeah.
I misunderstood the offer.
He can come back on the 13th if you want to, if there's been a
On
misunderstanding.
January 13th.
Yeah, but on that date, be prepared to do a plea either, and I can take a misdemeanor plea here. It doesn't have to be sent back down to district court and go through all that stuff again. We can end the thing here on the 13th or set a trial, okay?
Thank you, Your Honor.
Yeah. Ricky Phillips. Ricky Phillips. No Ricky Phillips. Counselor, you're not helping him conceal himself from the court, are you?
Trying,
Okay.
non-intentional.
They issue a bench warrant for Mr. Ricky Phillips. No bond, FTA. Terry Phillips. Commonwealth versus Terry Phillips, 21 CR 0006. Are you Terry Phillips? Hey, what's the Commonwealth have in this case?
We had an agreement, but it wasn't signed, so I guess we did a trial. We do, Your Honor. I guess sometime in April or May. Unless you want to say.
Is this a cattle case here?
It is, yeah. $350,000 case.
Mr. Cross, will you come over this way, over that way? I want over a little bit more. Now, get where I can hear you here. This is, what, why do we have to wait so far out? No, I mean, well, no, I'm just asking you have a special need. I don't care. Obviously, you have a right to suggest anything you want. I wasn't meaning that.
I was just thinking about the trials. Your Honor, I will add this. Mr. Phillips is doing everything possible in 2 states to try to collect the money that he's owed. You know, the longer it goes, it may be that he can come up with some money to pay on this. But at this point in time, he just can't, in good faith, sign an agreement to repay me yet. He doesn't have the ability.
Well, this is my position. My dad and mom on the grocery store when I was 12 years old, and this guy had trades on the account, owed $1,000, and that's big money back then. And the guy probably didn't have much money, but my dad told me something. He said he could pay $1 a month if he wanted to, if he wanted to pay something. And Mr. Phillips could pay something on this, but he don't want to. Well, I told Mr. Cross to come back with another figure. I never got there. So that's my position. If he doesn't want to pay anything on this, fine.
Well, let me ask him right now, because I know what you don't think. He's wrong.
Well, $1,500 a month to make a pretty good payment on.
While he's trying to collect this, he pays something.
Yeah.
What? 1,000 a month. You'll do that. You'd have to pay program. Just can't pay for 60 months. And first.
Can you do a diversion and hold it until it's paid in full?
No. Well, I'd have to move to the voting in 5 years. I don't know if I'll be around 5 years in this job or not. And I don't know if I remember.
Well, the rapture might come, the rapture might come, Mr. Cross can handle this all by himself that way.
Yeah.
Yeah. You know, these, the problem that you get with, have you ever been convicted of a felony before? Okay, the problem that you get in the kind of business he's in, if you're a convicted felon, that kind of ends it right there, doesn't it? I understand that ultimately we might have to do that, okay, but I'm just saying if he entered a plea.
Well, I tell you what, let's do.
Okay.
Let's do 5 years, 5 years pre-trial verdict for $1,000 a month, at the end of 12 months, we review the trial. And we set the version side.
He'll do the trial. We'll do that.
Well, I figured you would. I mean, that gives a man some opportunity. I have some experience in having clients who get on the wrong end. You can work your whole life and build up pretty good in 2 loads of Indian rural run yet. That's the reason, though, that you, in the business, you get, when you make pretty good money when it's working, because it's not risk-free, is it, you know? Yeah,
I'll have $1,000 a month, the balance due in 12 months, not to be set aside for trial.
okay, let's do work up a pretrial diversion.
I look at 1,500 or 15,000, I think up there, they have that.
I see no reason to believe he's a flight risk. So we'll apply that 15,000 there and then $1,000 a month, okay?
That gives you 12 months, we will get some money or.
And that also gives you 15,000. Yeah, it also gives you 15,000 to give people that lost some money, and that's more than they thought they'd ever get probably. Okay, if y'all do an agreement, we'll try to do it today. And that way you'll have it behind you before Christmas, okay? Okay. He knows to stay around, doesn't he? He's not late. Okay. Troy Pryor. Commonwealth versus Troy L. Pryor, 21 CR 0059. Are you Troy Pryor? Your last four digits, social security number 8761, and the year of your birth is 1962. Okay. We're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation parole? Okay. Is it substantially correct? Is it correct? Well, if they get dismissed, you don't have to worry about them. Won't you step away and? Okay, why don't you take him in the back and go over it with him? Sure.
On the jail criminal case, the state says if they have to use this computer, it might take, so they won't give them nothing. Mr. Cross and I have discussed this case because he wants to discover it, and I want to get tried. With the court try this case on January the 11th, December 10th. Did his discovery. We already have court that day. And
You want to take the code case off?
they had to leave it as a backup in case Mr. Strauss will not.
Oh, I'm sure we'll be trying this case. Wait,
Whatever you want to.
wait a second.
Like you said, just don't continue anyway for these things.
Well, I know, but that was,
I don't think we'll be finished in time.
we don't have a very long civil document. I read through it. It didn't seem like it's going to take long.
It may not take long, but it is a long document.
Right.
So that trial, they didn't want to start, they didn't want to promise on that.
Like for tomorrow, today. Well, on the 11th, we've got the Cope and Whitehead.
I'd rather this.
Well, yeah, but we got, on the 12th, we got a Monroe County
That's
case.
a special judge. We're getting special judge on that.
What is it? What is a flipping case? Why am I off of that?
Because you scheduled all those on the
That's
same
right.
day.
Okay.
Judge Patton, I got an email this morning. I think he's going to take that case
Yeah, we got Commonwealth versus Stevens
on Monday.
on Monday. And then we got,
We could say only on the left.
well, we got Clinton. We got Cope and Whitehead.
I know, but this would take the rest of it.
I really don't see that, I remember that tape. I don't think if we get it by the close of business tomorrow that we'd prejudicial.
Look at, that's fine. If we get.
Yeah.
That's fine. Leave it on the 20th.
Well, I'll tell you, we'll leave it, and if you don't have it by the close of business tomorrow, then I'll continue, okay, because
I'd
that,
rather it be done.
myself.
I know you had, this 10th and 11th, I've got a special judge coming to Monroe County because I schedule these other cases. And I don't have any, so I want to get a couple of cases out of the way since we've done that. Judge Patton's coming over there to try the case, so.
I didn't want this to be.
Close the business
laid out
tomorrow.
there.
Close the business tomorrow. Okay? And I appreciate the clerk's office letting us know in time. Appreciate it. Now I have a short, short,
He's reading his PSA.
yeah. Are you ready for Mr. Pryor?
Yes.
Okay, Mr. Pryor, you've taken a few minutes to read it. I think we were down to the point where we're going to announce the sentences. Are you satisfied with this agreement? Now you understand it? Well, you have every right to ask us to give you some time to understand it because I want everybody to understand what you're doing, okay? Okay, upon a plea of guilty to trafficking, controlled substance first degree, the defendant shall receive a sentence of 3 years, or 60 days in home incarceration. Balance probated for 5 years, probation to be supervised. Home incarceration, if you already been in home incarceration, that time has been running, it looks like. What is the court cost in this case? $155. Well, you need some time to pay that. Okay, I'll let you pay it $30 a month. First payment starting 30 days from today. Okay, that'll get you past Christmas. All right. If you need to meet with probation and parole officer out there. Rains. Commonwealth of Kentucky versus Angie, AK Angela R. Rains. Are you Angela or Angie Rains? Okay, you're here today on a review, it says.
She was shot probate, so she could take care of her mother who has cancer, and put her on a curfew and home. She's been on home incarceration for the last night. She's now got a lab confirmed positive test for me. So I have to be moving and put her in jail rather than do it.
I approached her.
Yeah.
I emailed it to Miss.
And you can send it over here and let them print.
She's already got it.
Is it printed? You can send it to the clerk's office and they'll print it.
Okay.
Okay, you have anything to say about that?
Judge, I probably need to be reappointed. I think this was the pro se motion that got her shot after she hired a private counsel.
Who was the private counsel?
He was never retained. Mr. Bertram had her, Mr. Son was never retained, but his office assisted in preparing pro se shop motions. So he was not retained as counsel.
Yeah.
But she did have Mr. Bertram previously.
So, Judge, I would just ask, I think we need to follow motion. She's currently on probation, so if there's been a violation.
Probation officer, that's cool. Yeah. I will be filing a motion.
Do you want a warrant for her on this violation?
I will be requesting revocation, sir.
Okay. Just take her into custody and we'll prepare a warrant and serve it on her. Okay. I would assume a warrant's necessary. She's in court. I could just order her into custody
I
without a
can just
warrant.
do a commitment order.
We would just do a commitment
We'll
order
have a revocation hearing next month.
on January the 13th. Yeah. Chad Scott.
Your Honor, this is a handling case, right?
Chad Scott, 21 CR 0068. And you also got Robbie Joe Scott, 21 CR 0069. Who you got, Mr. Stockton? You already gone through plea negotiations on this?
Yeah, I think we did need to call that at least once.
Okay.
We still have some investigation to do on our end, and my investigator that started that, we've got quite a bit to do.
Is that Powell case going to go?
No, we've settled it.
Okay.
We're not entered the plea, it should be entered first.
Okay, how about the 24th and 25th of January?
Yeah, I don't think.
Well, that's a month and a half.
I understand that, but, we've got some people we need to find. I'd ask for a little more time on that, they're out on bond, I don't think there's any problem about the behavior.
How about the 14th and 15th of February?
I'm setting everything on my Casey Circuit day.
Well, how about the 15th and 16th?
I'd rather do 14.
Well, the 14th is Valentine's Day. Not that I have any particular interest in Valentine's Day. But some people do. So. How about the 21st and 22nd?
That would be better for me.
And do we have waivers signed by them on due representation? Give it to Bales or you want to. What was that date? Yeah. Before. 21st and 22nd February. President's Day is not a holiday any longer, is it? Unfortunately. Okay, there won't be a need for any other pretrial, I would assume. If you have any dispositive motions or anything, whatever you have, you need to do them by the January rule day. Mr. Stockton?
Yes, Your Honor.
The January rule day, I won't schedule a pretrial unless y'all want one.
That's fine.
But if you do, I told him any motions in limine or suppress or anything like that would be have to be filed with that date, okay? Okay, thank you. Jamie Nicole Scott. Jamie Nicole Scott.
You could ask the officer.
continue back to the negotiation date of December the 20th.
Commonwealth of Kentucky versus Jamie Nicole Scott, 21 CR 0026. Ms. Scott, what's your year of birth? Okay, what are the last four digits of your social security number? Okay, pull your mask down just a little bit so we get a shot of. Okay, you put it back up. What does the Commonwealth have to say on this?
I don't mind another negotiation conference. We've never had one because she just didn't show up for one, and then Karen's had to be out. And I'm getting a lot of complaints on her about running around. She's supposed to be home, a lot of traffic at her house in Cumberland County. So I don't want this case off.
Okay, what, that will be on the 22nd,
Yes.
December 22nd. You'll be here for negotiation. You'll be here next upon January 13th. What are the condition of her bond? Pre-trial still on there?
I'm still here. I'm pulling it up.
Okay.
It was 15,000 surety, posted bond on warrant, clerk approved surety, 24-hour curfew except for work, church, doctor, random drug and alcohol testing, and other standard conditions.
I want to ask you if you've been complying with the terms. And I want to ask you if you have a party house going on with a lot of people coming over there. But I am telling you that if you want to remain on this bond, you're going to waive your Fourth Amendment rights for search and seizures, and I'm going to authorize those officers to go into your house. You understand what I'm saying?
Yes.
You don't need to dig your hole any deeper. You understand that? I believe your attorney will tell you the same thing until you get this over with, and then maybe you can start a new lease on life. But until then, you know, sometimes people lie, especially some people catch you down and kick you a little bit. I don't have any direct proof, but there's smoke there, so I want to give you a chance, okay? Okay, attending both these things are part of the condition. You got anything on her?
I know.
Okay. Okay, see you on those 2 days, okay? Won't you set that down on a piece of tablet paper and give it to us? Okay. Commonwealth versus Sexton. Commonwealth versus Sexton. 21 CR 00111. What's your full name, please? Okay, what's the last four digits of social security number? Okay, your year of birth, 1999. Okay. Your day for the purpose of arraignment. Do you understand that? You have any questions about it, you need to step away and ask your attorney. You have a right to remain silent. Possession of drug paraphernalia, possession of marijuana, possession of controlled substance in the third degree, and possession of controlled substance in the first degree. You understand those charges? You acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea or not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay. 22nd.
Your Honor, in drug court, Cumberland County, I just asked to continue this case generally. She's in drug court, Cumberland County, on another case. And if she completes drug court, I will dismiss this case rather than go ahead and prosecute.
Well, is that pretty good news? Gives you another reason to complete it, doesn't it? You have children? How old? Well, it looks like you're going to have Christmas with that child this year, and from here on out, you can determine whether you have Christmas with the child again, or not, you know? So you got a lot of incentives. So I'll continue it generally upon the motion of Commonwealth. Jimmy Simmons. Commonwealth versus Jimmy Simmons, 20 CR 0085. Are you Jimmy Simmons? Pull your mask down a little bit, and then you can put it back up, okay? You're here for pre-trial conference. What do you have, Mr. Stockton?
I would ask for a trial date, Your Honor. We need a few months because I've got witnesses from Buffalo, New York, and South Carolina.
Okay. Do you need any kind of domestication of any?
Yeah, once I get a date, I can follow.
Well, I can go ahead and enter order on that now. You just submit it. We won't have to, doesn't appear to me, we're gonna have to worry about March being too cluttered up like it used to be, so.
Oh, you're not gonna have to worry about that now.
Mr. Cross might have to worry about more than we do.
I wouldn't think.
I'm reading really well, Sarah.
Yeah, that's what I said, yeah.
Get rid of ESPN on my satellite.
March the 29th and 30th.
Well,
What?
I kind of like, if the court will go on and put this case out.
Okay, I can do that.
We'll move it up a little earlier.
When is it for you? When do you want it?
The 11th and 12th is for you of April.
Right.
We go in the May on this.
Commonwealth versus Clay will be tried.
We just said that. Today.
Oh, yeah, that's one today. We can do that on the 26th and 27th. I know I set the other one for 2 days. But
It's hard for them to do subpoenas when
okay.
you
All
don't
right.
know if it'll start that day. or not.
Okay. How about May 9th and 10th?
That's fine. with me. Looks good.
Wait a second. It's May 9th and 10th. Okay, I guess we need to have a pretrial on this in February, on the February rule day to make sure all the discovery and everything's in. Okay. I think I had CG.
Or you see what-
Yeah. Let me see that. I need to take about a 2-minute break here. And recess.
I could have watched it.
How long are we off? How long did you watch it for?
About 12 seconds.
Those that cancel that game.
Yeah, we're going, if everyone takes positive. Tonight, tomorrow night. Maybe during the week.
Oh, they're gonna do that drive too.
That'd be quarantine, at least that hand gets
We're full for 6 weeks.
better. Yeah, you know that. Only player they want. He's like, he hit John Allen's son in the eye socket with the shoulder and broke.
Well, that's, I knew it was something up there. I just couldn't. That's crazy.
Commonwealth versus Patricia Diane Smith, 20 CR 0033. Are you Patricia Diane Smith? Okay, you need to pull your mask up over your nose, okay? You're here today on the pre-trial conference. Y'all have an agreement?
We don't, I don't know what the Commonwealth.
Put a month on misdemeanor, stay away.
Well, I didn't know about.
Come here on December the 22nd for negotiation, and the next court date's on January 13th. Karen Tuggle. Issue a bench warrant for Heron Tuggle. FTA. Joe Edward Turner. Commonwealth versus Joe Edward Turner. 20 CR 0065. Are you Joe Edward Turner?
Yes, sir.
You born in 1965, last 4 digits of social security number 8351.
Yes, sir.
Okay, you're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done on probation parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
Is there any reason why this gentleman should not be sentenced today, Mr. Sheffield?
No, you won't.
Upon a plea of guilty to traffic and controlled substance first degree, the defendant shall receive a sentence of 5 years probated, however, 5 years supervised. He shall pay back by money in the amount of $400 at the rate of $100 per month. The first payment being due 30 days from today. All monies being paid to the clerk's office here with 5% restitution. But you shall receive credit for time served. Court costs the amount of $155, and I'll allow you to pay that at $30 a month, the first payment starting. Can you pay the $130 a month, 100 and the 30?
It's difficult.
Well, I'll tell you what I'll do then. I'll let you pay the $100 a month. And then when that's over, you can start paying $50 a month toward your court cost, okay? Okay. All of the paraphernalia drugs shall be destroyed. Okay, you need to meet with probation parole officer. Alicia Dawn White. Can you hear me now, Ms. White?
Yeah.
You pull it up over your nose. Commonwealth of Kentucky versus Alicia Dawn White, 21 CR 0079. Are you Alicia Dawn White?
Yes.
Born in 1986?
Yes.
Last four digits, social security number 1354. Here for a pretrial conference. Have y'all reached an agreement?
We have a pre-trial version for court.
Okay. A motion has been tendered that says you wish to enter guilty plea to that. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol? Is the plea freely and voluntarily done?
Yes.
Okay. Are you the same person named in this indictment?
Yes.
Do you understand the charges against you? Have you had plenty of time to discuss this with your attorney?
Yes.
Are you satisfied with his advice?
Yes.
You have certain constitutional rights that I need to know you understand before I can accept a plea. You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to a higher court if you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charges against you. By entering a guilty plea, you give up those rights. Now, I understand that this is going to be a pretrial diversion, but before we get there, have you previously been diverted in the last 5 years?
No.
Have you had any felony convictions in the last 10 years?
No.
Are you currently on probation? Do you waive the right to speedy trial?
Yes.
Have you reviewed these diversion terms with your attorney?
Yes.
Do you understand that?
Yes.
You realize that if you breach the terms of pretrial diversion, come back in front of me, I revoke your pretrial diversion. I'll have a pre-sentence investigation report done by probation and parole. You'll be a convicted felon. Do you understand that?
Yes.
If you'll step to the side, both of you, Mr. Carter is going to say, Mr. Carter, you'll need to speak right in the microphone because she's hard of hearing, okay?
Your Honor, the Commonwealth offers on a plea of possession of controlled substance first degree, the defendant would receive 3 years pretrial diverted for 5. On the DUI, the DUI third offense, the defendant will pay a $350 fine plus 30 days in jail. And on the failure to maintain insurance, on guilty plea to that, it would be a $1,000 fine and cost. The other charges would be dismissed. The defendant would be referred to the social services clinician and follow all recommendations. Receive credit for time served, pay fine and cost at your discretion, obtain gainful employment of 30 hours per week community service, remain on active supervision until all fines and costs and restitution is paid in full, and all contraband will be destroyed.
Okay, ma'am, you realize that this DUI that you're entering a guilty plea is enhanceable too. If you get another DUI, the penalties could be more, including felonies. You understand that?
Yes.
Now, is that insurance enhanceable now?
It is.
So it's enhanceable also. So both these are enhanceable. If you don't have insurance, or if you get a DUI, or you got a felony conviction. So all these things are enhanceable. You understand that?
Yes.
Okay, well, what are the court costs and fees and service charges?
Total everything's $920, Judge.
Total of everything is $920, and you need some time to pay that?
Yeah. Okay.
Okay, how much, can you pay $100 a month? Okay, well, you pay $100 a month, your first payment is 1 month from today, okay? And you pay $100 a month, you pay that $900 and whatever it is. You can prepay it anytime you want to. Okay, is there anything else you have?
She have her days in.
Does she have her days in?
Yeah, she's over.
Okay, is that your signature on there?
Yes.
Okay, you'll need to meet with the probation parole officer over there, and I'll sign this pretrial diversion.
In Boston's home. That's all it's. So it's survived. They put it in its car seat, and it was thrown from the house to the neighbors inside the car seat.
It's almost more than a person can bear. Who's young girl supposed to sign it? Is Alicia White the next one? That's Alicia White. Korea Talina Whitehead. How do you pronounce your name? Kalira Talina. Yeah. Unusual name. We have an agreement in this case.
Judge, this is a co-tenant, Mr. Cole.
Except the child.
When it was previously taken up early with the docket, and they were both.
Mr. Stockton, you trying both of them at the same time?
Yeah.
January 11th. Okay. Yeah. Now, do we have anything else?
Mr. Phillips is fleeing.
Mr. Jones
Mr.
was.
Jones, Lake County Jail, he wasn't back.
I never,
Jones is the only one we have left in.
no, Jones and Ricky, or Phillips.
Where are they at? Both of them in jail?
That paperwork may or may not, y'all may or may not have that.
Okay.
Yeah, the cattle guy, we don't have his paper.
Back there signing.
And then the other one is the guy that's in jail in Clinton County, right?
Yeah, we passed Jesse Phillips, and I was unsure about that. I thought we passed him.
Yes. And I'm gonna have to pass, Richard Guthrie. I couldn't find him in Vine anywhere. And Mr. Wittenberg told me he is in Eastern Kentucky Correctional Complex, so I'm gonna,
Just a second, I'll tell you. Sure.
I looked in Vine and Cool, could not locate him.
Okay, I'm gonna go off the record here just for a second. Y'all can search down these last two people. Commonwealth of Kentucky versus Terry H. Phillips Jr. Are you Terry H. Phillips Jr.? Okay, we previously identified you in 21 CR 006, last four digits, social security number 9701. I understand that you wish to enter a plea of pretrial diversion. Is that correct? Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given? Is it? Okay, is this 21? Are you the same person named in indictment 21 CR 006? Okay, are you satisfied with the advice of your attorney and you fully informed about your case? Okay, you believe you have certain rights under the Kentucky United States Constitution. Before I can accept a plea of guilty, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to a higher court if you lose, the right to require the Commonwealth prove on a reasonable doubt that you're guilty. By entering this guilty plea, you give up all those rights. Now, I may consider the Commonwealth's recommendation, but in this case, you're entering a pretrial diversion. And I've got some questions I've got to ask you. Have you been previously diverted in the last 5 years? Do you waive are you on probation? Are you having felonies in the last 10 years? Do you waive your right to speedy trial? Have you reviewed the written motion for diversion with your attorney? Is that your signature on there? You understand and fully complete that you fully complete the diversion programs, the diversion agreement, that your case will be dismissed and you will not be a convicted felon. But if you fail to complete the diversion program and you're revoked, I'll have a pre-sentence investigation report done by probation and parole. And you'll be a convicted felon. You understand that? Okay. Who's going over this, Mr. Stockton? Okay.
Yes, Your Honor, he pleaded guilty to theft on lawful taking over $500, 2 counts, 5 years each, around concurrent for a total of 5 years, pretrial diversion for 5 years. That will be unsupervised. He lives in Tennessee. He agrees to pay restitution amount of $301,807, $807.07 at Bluegrass Stockyard, rate of $1,000 a month.
$15,000 down.
That's right. I need to do the rate of $30, 30 days, and then it is plea. And the entire balance will be due at the end of 12 months. The $15,000 bond will be applied for restitution.
Is that what you agree to, sir? Okay. Okay, who has the document there? You give it to the bailiff there?
Yeah. This is meant to leave today.
Somebody might check some of those documents I signed today. I might have put 12 on that. No, it's hard for me to do these. I might make a mistake. Okay, you need to meet with probation parole officer over there. Okay, now do we have one other person down in jail looking at something who has a
John, we need to take care of
Jones?
I don't know if there's anything to be done. The jail's not with us anymore.
Who is?
The jail's not with us anymore. So you might want to find out what, if he's gonna take the plea.
Is he gonna take a plea?
Your Honor, I haven't spoken to him.
Okay, Mr. Mr. Stockton,
Yes, Your Honor.
could you come up here? Before I get the jail back on, I want to know if he's gonna take a plea or not. What's the story?
No, Your Honor, not today. I had spoken with Mr. Stockton regarding Mr. Jones. And, what I would request of the court is we can continue this for, till the January 4th date, to allow Ms. Hill to go and, speak with him at the jail.
December the 22nd is a plea day. She needs to be over here or have you over here prepared to do it. Since you'll probably be coming back over for Christmas anyway, you might just come over and stay a few days. December the 22nd, and then back in court on January the 13th, okay?
Thank you.
Thank you. That concludes the criminal docket of the Clinton Circuit Court. Turn us off on everything here. Okay, the child support docket. Got your whole crew back with you today. You have, I thought you might file a motion against Calipari for not having anybody that can hit a three-pointer. I find him guilty. Shelton versus Shelton. Y'all picking up on that microphone there. Y'all are picking up on that microphone there. Sloan versus Sloan. Cabinet versus Catherine. Okay. Smith versus Jacob Allens. Smith versus Smith.
I'm going to pass this as an act of contempt and he's incarcerated this time.
And who is this Jacob Allen Smith? Who is this? No, I didn't mean it. McGall versus Barber. No.
Well, no, what this is about. We was trying to say it here. No, we're just trying to figure out the visitation.
You know about the post office closing tomorrow, Buster?
Wow.
They just sent me a sign to approve for the front door. And I don't know anything.
What is tomorrow?
Kristen McGall is up
Wait
there.
a second.
Okay, Kristen McGall is up there.
Call them and ask them
So
what.
they're closing at 2 tomorrow.
Why?
I don't think it's the same.
Okay, what do we have here?
Your Honor, this is our motion to increase child support and thank the divorce attorneys are here on the, I guess, the amount of time spent each. Just for our purpose, it's a motion to increase based on income and the last number that's in the court, visitation of the custody is not changed as far as we can see, so it's the same setup.
Well, I'm not going to hear any custody part of this. Is the child support
No,
docket.
Judge, I guess, in speaking with Mr. Raines, it's my understanding that they're basing their figures today in their motion on the previous order we had before we went to court and reached an agreement. And so I just asked.
When did you go to court to reach an agreement?
We went at the 1st of November, and then we've had drafts going back and forth of what.
So there ain't any agreement then.
Yes, there is. We stated it on the record before the DRC. And the parties were sworn that they were obligated to follow that till it was in writing. So I just asked that we continue this for a month to make sure we've got that agreement in place because of the change in the.
We'll just tell them today what the agreement is. And if all the parties are here, they can recalculate today.
You're typed out a document which sits out there, time sharing the number of days.
I'm not going to get into any time sharing.
Judge, essentially have 1 week where my client has Tuesday through Thursday.
Okay, what does that have to do with the child support?
Because of the change in the child support statute in June, now they have to consider split custody when they go to calculate it under 43212. And so if there's a change. in
Well, the
time-
order is not in place, so he is obligated to enforce the orders, my point. So if there's no judgment in there, y'all can redistribute the money if you want to.
This time, we should be allowed to proceed because the last order that's in the file is not changed.
How much you got? What you got?
Go to 660 a month, with the increase from 660 from
I think it was 500. It was 433.
660.
Effective when today?
Had in the order December 1st, the motion was filed in November.
Well, if the parties are in agreement with it, but I don't want to, I want y'all to get that to them today and see what that does to the calculation. But if they don't have it, what time you closing today? 4? Well, I want it in there to them at the close of business today, or I'm gonna sign the order they're submitting, okay? Yeah. The Honorable Bowles will take care of it. Okay, Cabinet versus Hutchison.
She's out there.
Okay, Cabinet versus Hutchison.
Yes, Your Honor, in this case, since the orders paid $460 a month, current 92 of arrears. And the arrears at this point is $1,380. And Liz asking the $700 to be paid by January 12th.
She's ordered to pay that?
Yes.
How many, is this an arrearage or the children involved?
No, there is children involved.
Where are the children? Well, you'll have to go up through the regular process about visitation. How much a month is she?
It's actually set as the minimum wage amount for 5 kids, $460 a month.
Are you working anywhere? Why are you not working? You ran out of time. If you can't tell me in about 30 seconds, you can't what?
I cannot mentally work right
Okay, are you under a doctor's treatment?
Not yet.
Well, there's nothing I can do for you unless you get disabled or something like that. And there's nothing the county attorney's office. Do what?
I'm gonna try to sign up for it.
Well, the problem is until you do something to help yourself and your status, the county attorney's office is obligated to enforce this. You understand what I'm saying? I don't see how in the world you can come up with $500, 500 or 700. We might as well take her in jail, and put her at Christmas for 700 because she's not going to be able to come up with $700. You think? Can you come?
Honor, we can give her a couple extra weeks. We can-
I mean, I can make an effort.
Okay, well, I want you to,
we should push it out.
yeah, push it out to about January the 6th. That'll give y'all time to notice it back again.
Right, now it was January 12th, Judge, when you,
That you're already gonna do it,
well, no, that's what they originally had to have to do.
had to purge by, well, you might be able to do it by January 12th. then,
That's
but
the day you had January 12th.
you might be able to get your payment made by January the 12th. So that's, how much is the total arrears?
Total arrears is $1,380.
Okay, I'm gonna take it down to $500.
That's
Okay, I'm taking it from 7 down to 5. You have that $500, and how much a month is she paying?
$460.
Well, what I'm gonna do is, I'm gonna make it 560 a month. Okay, so you pay $100 extra every month instead of having to come up with 500 and then another 500. Okay, but you have that paid in full by January 12th. I want you to come back up here on January the 13th anyway. And I want you to report to me what you're doing about your mental state and what you're going through and everything, because these people need to be made aware of that, or you can go meet with them about that. I would just tell you this, that this time of year, a lot of people have depression of various kinds, especially if you have problems with not visiting your children and things like that. I don't know what's going on in your life. I don't know how these children have been treated. Something happened to you if you lose them children. But there also ought to be some way that you can establish. So you need to find a lawyer somewhere and have somebody review your case, okay? So they'll give you the exact date that you have to have this stuff, okay? And what I want this order to do is just add another $100 every month to her present obligation, okay? Won't be any doubt about it. I doubt if she can pay that anyway, so. Move in with you, she move in with you. She move in with you. Hey, I've quit preaching and started meddling now, haven't I? Okay. Okay, that concludes the Merry Christmas, y'all. Yeah, okay. We got, let's go off the record. We got 10 minutes before the civil docket. Okay, let's start the docket. First case is US Bank as custodian for SAS Municipal DTR versus Ray's Refrigeration and others.
I'm hoping no one appears on the other
Well,
side.
you should. I read your pleading. You should hope no one appears.
The purpose of my pleading is thank you, thin air.
Who's the attorney on that side?
Aaron's lady out of Cincinnati. I talked to Gormer down too, and she's bailed out. And
So your motion says that this US Bank and those folks have gone out of existence or what?
the only people listed against is a third party tax person. Fast Beauty or do that. Not even Fast, they build this up, whatever it is, the third party tax servicer is out of business. So they can, they alone.
I sure hate to rule against one of these tax parishioners, you know. But you give me an order. I mean, obviously, they're not authorized to do business in the state anymore. Is that correct?
Correct.
Yeah.
Yeah.
Okay, well,
I'll hand it over, I'll hand it over.
send her an order. Okay. Papinal versus Husted. You want to ask them, you see if your clients want to come in here?
We can, I think.
I always found it's easier to practice a case if your clients aren't around to interfere. So.
I'm doing good, how are you?
Okay. This is a case, it's Papinal versus Husted. It's a case where there was correct me if I'm wrong here, where there was a will done and then there was an attorney in fact appointed, and the attorney in the document that created the attorney in fact did not specifically give the attorney in fact the ability to donate or to give away the property, especially to themselves. And your position is that it's a matter of law and there's no factual situation for the jury to decide. Is that a fair?
That is, Judge, because in the, before this statute, it said that you applied the utmost good faith standard, but the statute was basically, if you look at the history of it and the way it was written,
I was involved in it.
was to do away with that issue of the utmost good faith part. And that's actually what Judge Russell ruled in the blind case, BLIN, that we cite to.
Federal case.
It is a federal case. There is another case, the Ritchie case, Judge, that was authored by.
What do you have to say about this, counsel?
Well, I have a whole lot to say about this case, Your Honor, and I filed a response with the memorandum attached to, which details the position of defendant Teddy Papinal, being that this statute is, the defendant will concede that the construction of the statute.
Okay, I'm just wanting, I don't want to talk about the equity of it, what should have been done, who was right or wrong, or any of that sort of stuff. I just wanted you to answer his position that if the power of attorney that was created failed to give the attorney in fact the right to gift this thing, whether or not they can gift it.
Well, Your Honor, I believe it all turns on the construction of the statute and whether or not the statute, the way it applies to the power of attorney issue in this case, Your Honor. The statute says that the intent to give shall be unambiguously stated on the face of the instrument. Our position has always been that the power of attorney gave Margaret Husted plenary power to transfer and to make conveyances of every nature. And so
the problem that you have with that, and I was in the legislature and really was on the wrong end of one of these cases years ago. The problem that you have is that the word gifting, every one of those others things that, where they can defease the estate or transfer the estate. There will be certain standards that you can apply for that. The gift is different than all the rest of it. You might sell, they might have unequivocal power to sell at some price, and then you could get into whether or not they breached their fiduciary duty as the attorney in fact. But gifting, there is no standard. And this has been a long thing. It's gone back and forth. The statute has some case law on it at one time. And I don't think that you can fail to differentiate the word gift from all the other ways that you could alienate this property. You think gift doesn't need to be there? If it doesn't need to be there, why is it there? Why they change the statute and put gift in there unequivocally on the face?
And Judge, in fact, they are.
Let him answer that.
Yeah, and Your Honor, the way the statute was written, it didn't say that the gift needed to be explicit, the power to give needed to be explicitly stated on the face of the document. It was the intent of the principal to award or to grant the power to give, and it needed to be stated unambiguously.
Is it stated unambiguously in this document?
We contend, yes, Your Honor, we contend plenary power to transfer and plenary power to convey, but
well, then the statute would be unnecessary.
Well,
That language.
the legislature agreed because they repealed it in 2018. I mean, so the reasoning behind the statute, I mean, it was only for a very brief period of time. The legislature, in all its wisdom, decided to repeal that statute. So to state that it was a powerful statute that controlled all sorts of.
Wasn't too powerful, but it was 100% powerful at the time. Now, let me ask you about this question. Let's say you have something that's done, and then subsequent to the act, the legislature comes in all of its wisdom and changes the law. The question is, which law should apply to the transaction that happened then? I always had problems with them doing that, because that meant that all these documents that might have been done years before, predicated on what the law was, would have been affected by that. And this power of attorney, was it affected before the law was changed to say that you had the state gift on the front of it?
No, it was done in 2011, just while the statute was in.
While the statute was still in. I just felt like it was.
Both the power of attorney and the transfer.
I always thought it was very unfair for the legislature to change that, and you had all these documents. If there wasn't anything in there that says any document predated so-and-so, was it? Yeah.
However, I must note though, and I have failed to include it in my memorandum, which I would be happy to supplement for the desire, that the new statute, Uniform Power of Attorney statute, is retroactive. Further enabling at the very, on the side, I wish I could give it to you, Your Honor, but I don't have it at my ready disposal. But the statute says any power of attorney document that was drafted on or before June the 15th of 2020 shall be affected by the Uniform Power of Attorney statute.
That still doesn't apply here.
Why did it apply?
Because it was done before.
It specifically states on, before, or after. And I'd be happy to supplement that. I'm not telling those.
Did the state adopt the Uniform Act?
Yes.
When was that?
That would have been in 2018, 19 transition, and then 2020. So it's been a process of the course of the last 3 years where pieces of the uniform program.
What always bothered me with, and I appointed the people to this national uniform law stuff, John McGarvey, who's Senator McGarvey's dad, I always appointed him. The problem that you had is you change these things and then somebody wants to come in and amend them so they're not uniform anymore. Now, what's your argument that the change of that law didn't affect this?
And I'm not aware, she's not putting any of that in there. I thought the date they said was 2015. This was done in 2000. The power of attorney was signed in 2011, and the deed transferred the property, I think, was 2014 or something like that. And in essence, what they've done is if Mr. Papanoff, the testator and the.
Well, it defeated the purpose of his will
Absolutely.
by the attorney, in fact, signing a document that was contrary to the express term of a will that whose validity has not been questioned.
Right, and it's bypassed the strict adherence that Kentucky requires to have two witnesses, verify all that stuff. Here, we don't have any of that. And
Well, this is a difficult case because I don't know a lot of the underlying facts. And it could be very well that the elder, Mr. Papineau, told somebody to do this or something like that. It could very well have been.
actually, the Ritchie case says that it's not.
I know that. I'm saying it could very well be that he told somebody to do it and it still might not be effective. Because that telling somebody to do something is not testamentary act, doesn't have to meet, it's a bad set of circumstances here. A bad set of circumstances. Well, I'll give you some time to supplement your brief since you brought this new issue. It's not fair to counsel and you understand that. So I'll give you 15 days about the Uniform Act and to see about the retro application of it and see if the Uniform Act had been passed before these transactions took place. And if it had been, what effect passing it would have on retroactively on anything that had been entered into. I think that's a fair thing to do here. That seems like because I'm going to tell you right now, if the Uniform Act does not do that, then you're on a loser here. And it's going to take the Court of Appeals and the Supreme Court, and they might very well do that. I'm not saying they might not change that, but I would want more definition on this intent theory that you got, because I fooled with that things and kept them from changing it. But the entire time I was in General Assembly, which ended in 2000, they hadn't changed it when I left in 2000, but they tried a lot of times,
And Judge, if I could just also address that issue as well. And we may touch just briefly on, because we didn't get his response to Friday.
Okay, well, he's going to supplement his response and you feel free to address any part of his response. But you're winning right now, so I don't know what I'd say too much more about it. You might tweak his mind a little bit more. Well, this is not a funny thing. It's when you got family members and other people involved and things like this, and then the law would prohibit maybe things from being done as people wanted them done or as the decedent done. But I do think that you're correct that this is a question of law and not a question for a jury.
At this moment in time, yes, but
Yeah.
regarding the parent and the implied authority, though, also, Your Honor, with regard to these,
Well, you hadn't gotten across that bump yet.
I have.
No, and it's a hard one to climb to convince me that even if they were errant in what they did, the fact that they saw fit, that General Assembly saw fit to bring out the gift thing and said it had to be, obviously stated, prominently stated, that sort of thing, the gift thing. I don't see how you really overcome that, but I'm open to hear your arguments. So thank y'all.
That in and of itself, judges, if he's having to argue apply the 10th, that means.
In alternative, Your Honor.
It's not obvious.
Well, we're speaking in alternative, and that was the response that I said, that even in alternative, it's.
Well, sometimes when you're faced with inevitability, you start arguing alternatively. I will say that the entire time I've been practicing law, which is a little bit longer than David Cross, but not very much longer, I will say that I really never have had a jury that I thought decided something that was entirely wrong. I mean, in degrees, maybe they might have found somebody even in criminal cases, but I have seen the legislature on several occasions pass things that wasn't, as they used to say, ain't quite right. But I, as a trial court judge, do not have the authority to act upon those unless the statute with constitutionality or something was challenged. And I don't think we've got that here. Well, thank y'all both for making good arguments, and I appreciate it very much. Okay, Commonwealth of Kentucky, Clinton County Secretary of, what is that next one? I can't tell from the title here.
I have to look it up.
What is it?
No.
No, this is 20 CI 00129.
Commonwealth of Kentucky versus JP Silverton Industries.
Is this a quiet title thing? Is that what it is?
No, it's another thing, this is the airport sale, and.
This is just confirming.
No, this is my motion, I believe, to add a party to purchase and taxes. I found on title search, just to add them in, but we make sure we got all the taxes.
Well, you already sold it, hadn't you?
Yeah, I mean, we have no objection, I think you can add. You know, money here is first. They'll just get paid.
It brought enough to pay everything, is what you're saying.
It doesn't affect us.
Did it bring enough to pay everybody everything? So nobody, no harm, no foul. If it hadn't brought enough to pay everybody, somebody might have had a problem for not including it.
Well, they are included.
I thought you said he just,
They included at the same rate.
okay, I don't care. Okay, nobody's getting hurt. There's enough money. What I'm saying is if they hadn't been included in the initial lawsuit and there was a sale in judgment, some people might have been hurt as to the distribution if you allow them to later come in. You understand what I'm saying? If they'd have been omitted.
That's a possibility, yes, it's better add them out, for sure.
Yeah. I won't worry about what might have been. Okay.
Other cases you want to-
No, I'll just go down to the doctor here. I'll get to the other case just a minute, because
Okay.
I got them lined out here. Okay, it won't take long.
All right.
Tiffany Johnson and others versus Aaron Huff. She can do that.
That's what.
Hello?
I'm John Kelly. I'm with the firm of Williams Cow in London. We represent Geico Advantage.
Yeah, I read this thing for about 2 hours last night, almost stabbed myself. The question in this case here is whether or not Tennessee or Kentucky law apply. You had 2 Tennessee residents that got hit by a trailer that was pulling some kind of
Truck pulling tractor.
it was some kind of, it sounded like to me it was some racing car or something or whatever. And it was
That's what
alleged.
they're going to pick up. It was empty.
Yeah, and one of the worst cases I ever had was a case like that. But anyway, swung around, hit these people behind, that sort of thing. Who's Geico wants the Tennessee law to apply because you got an anti-stacking thing down there. And then there's a difference between uninsured and underinsured. Correct.
Tennessee combines it, but it doesn't, it has the same, almost the exact same language in its statute as does Kentucky with regard to uninsured and underinsured. It just includes underinsured within the definition of uninsured.
Okay, and what do you say about the uninsured and underinsured?
Martin Hagan for the plaintiffs, Your Honor. The word underinsured doesn't appear in its definition of uninsured. An uninsured vehicle is simply a vehicle that has less than however much liability covers the tort vehicle.
That's kind of the same, isn't it?
Well,
It doesn't mean it matters to me whether it's the same, but I mean, if your definition of uninsured is someone who doesn't carry enough insurance, that would make that underinsured too, now really, wouldn't it?
it can function that way. It also applies if the person was truly completely uninsured.
Yeah, and you're saying that these people had 2 different coverages in Kentucky, so they should have the benefit of both things they're paying for, is what you're saying.
Well, Your Honor, there are three different vehicles, 3 different premiums for UN coverage.
Well, that's a stacking part of it, right?
That's correct. Yeah.
I'm just talking about the difference between uninsured and underinsured. Are there 2 different policies there that, 2 different pots of money there, one for underinsured and one uninsured? So that doesn't matter.
No, Judge, it's all just one.
So it doesn't matter. So underinsured and uninsured doesn't matter. You agree with that?
I would agree.
Okay, so the question is the stacking thing primarily, right? Is there anything else you want besides the stacking thing?
Well, the other issue is the offset issue. So, so if Tennessee law applies, essentially they get a credit for whatever liability covers the tort fee. Credit or offset.
Yeah.
In this case, it's joint. The other fellow had a minimum limits policy. There's some argument that trailers, but I don't think.
Yeah, it was whether it was uninsured or not, right?
It's kind of a recent development, Judge.
Yeah.
I don't know that it matters. In that it wouldn't be uninsured.
Yeah. Well, it would have been interesting if someone had insurance on the trailer and didn't have one on the truck and they thought the trailer policy that would be, but it's not in front of me today, so I don't have to worry about that. Geico does business in the state, I see. And the two people were residents of Tennessee at the time, but one of them now lives in Kentucky, right?
After the lawsuit was filed.
Yeah. But listen, man, any excuse that I can get to locate anybody else in Kentucky, I'm going to take advantage of that. So no, I'm just kidding. Usually the migration is the other way. Now, are you kibitzing here? Come over and get Bob.
Sorry, Your Honor. John Jess with Berkshire Hospital. We defend Mr. Billy Bustler, who owned the trailer. The other defendant, Mr. Huff, he owned his vehicle. He was
Obviously,
hauling-
he knew they were going to swing the trailer around. That could have been anticipated. They were going to swing the trailer around, and hit somebody in the back.
Right.
Well, I might be wrong about this, and I could very well be, and I can be corrected on it. I read and reread these things pretty carefully, and both of them were very well written. Everybody did a good job on it. It didn't take a whole lot to confuse me on it, but I'm going to say that these people are bound by the laws of the Commonwealth of Kentucky. The accident occurred here. They couldn't get into federal court, it would appear, in any way, or everybody would have been there.
The defendant was a Tennessee resident.
Your guy was a Tennessee resident?
Yes.
Yeah. Did you want into federal court?
No.
That's the right answer. Nobody wants into federal court. Some reason do. I'm going to go ahead and go ahead and draw something just on the issue of stacking. Okay. And then the other issue was offset. And since I'm going with the Tennessee law, I might as well take that offset out too and give the court an opportunity to address that. And it appears to me that out of a sense of judicial economy, it'd probably be good to get these two law issues out of the way before y'all spend too much more money litigating the thing.
Just, my years are old, but
You lost.
I lost.
Yeah.
So everything is covered by the Commonwealth.
That's what I'm finding that they are. And I might be wrong about that, but I think if I take both issues up, that in the sake of judicial economy, I might as well know that now rather than try it and go and me ruling the other way. And that way y'all won't have to go through
Well, we do have to Commonwealth of Kentucky because one of the things, Tiffany Johnson was valid. I will admit, Jenna Johnson was not. And whether or not she has a claim she's maintaining one.
Yeah.
Would have to be resolved by a jury.
Well, I know they would, but I would hate for a claim to be resolved by a jury and then find out that we were operating under the other laws, what I'm saying. So I'd like to get this issue out of the way. And I believe that they're in the Commonwealth of Kentucky. The wreck happened in the Commonwealth of Kentucky. They were insured by a company that issues policies inside the Kentucky. And I just believe as far as conflicts of law, I will admit that that wasn't my strongest area in law school, and we don't deal with it very frequently. But there was a conflicts of law the last time I dealt with it was on the bar exam 40-something years ago, and I got it. And I might be wrong this time, got it. Okay. Is there anything else you got?
Judge, then the order will be considered final and appealable.
Absolutely. Yeah, absolutely. Yeah. I mean, and I think that's the thing we do. It'll be final and appeal, but you can take it up before we proceed with anything else on the case. If I'm wrong, we'll know what we're operating under, and it might help negotiations somewhat. I don't know.
But there's one other motion pending.
Okay.
Because of a mistake I made. One of the exhibits I made had Miss Tiffany Johnson's birthday It's not prominent, but it's there.
You asked for redaction.
Can I read that?
Absolutely. Nobody there, if there's information that's given, let's direct everyone to redact their file. And since it's not filed in our record here, we don't have it here.
Yeah, you.
We do?
You do.
Well, we'll make sure it's redacted. I tell you what I want you to do. I want all of you to agree, send me a redacted copy, and I will replace, with your permission, I'll replace that page in the file so y'all will all know what's been redacted, okay?
No objection to the motion.
Okay, well, thank y'all very much. Y'all have a nice holiday. Thank you for your patience, okay? Myers versus Myers.
Your Honor, that's motion. We filed Ms. Jackson on the other side. We filed a motion to adopt the commissioner's findings, first of all. And I don't have any objection.
Okay,
I have the order for that.
Mr. Baylor.
And I also have a proposed decree. We had previously filed a joint motion to submit, and this does have a language in there about the fifth class of any parties not taking it, that they shall not exercise visitation until they do so.
Any objection to that?
No.
Okay. Okay. Next one, Haddix.
Smith versus Dale.
Hmm?
Smith versus Dale.
Oh, yeah, I pulled it. Smith versus Dell.
Just all the parties after there.
And we do have an issue under submission in this case, but they filed a motion for mediation. So I just thought it's better to wait, see if they can mediate it.
What's your experience in practice law? Is that what your strong suit law?
Well, actually, I specialize in default judgment and collection cases. I'm the strongest there.
That could be lucrative. So
It can be. I never made much money, but I have a certain level of certainty there. It's my knowledge of the law. Well, none of us really do enough car wreck cases or insurance cases around here to keep up with the changes. So I don't know. I tell you what, your associate and opposing counsel both wrote great briefs on that issue before, and these people all are really good things. I think. Good. Okay, it's Smith versus Dell.
Yes, Your Honor. The parties are here and seated in the back of the courtroom. I brought a motion asking the court to order mediation in this case. If you remember, we went before the DRC. We filed numerous exceptions to the DRC report recommendation. And at this point, we believe that if the parties were to attend mediation, they may be able to resolve the issues that are outstanding. And so we've requested that the court order.
Your Honor, we've not agreed upon mediation. Of course, if this court orders it, we will comply with whatever the court wishes. I think that Ms. Hawley and I ought to be able to work things out without mediation. We've attempted to. It's not been successful.
Well, what are the remaining issues primarily from your point of view, Mr. Cross?
Your Honor, all we wanted to do was just to tweak a bit of the pickup and delivery schedule. And also we wanted to add a week of spring or fall work.
Well, there was the allegation that some visitation had been denied or hadn't been exercised, wasn't there? Was there?
So in the issues that were before the DRC, Your Honor, there was an issue of whether or not the father had been exercising his parenting time that he's being allowed to. And the issue was that the restraints that the respondent had put on him in order to allow him to exercise that, it was required that he be at her parents' house in their presence.
I don't worry. Tell me what issues you think you and Mr. Cross can work out through mediation.
Your Honor, right now, the issues are when will the child start school? And what will the parenting schedule be up until then? At this point, my client is seeking to have additional time rather than what was recommended by the DRC. He's looking to have regular parenting time with the child every single week. Under the recommendation, he was not getting anywhere near half of the time. And so he's looking to have.
Well, of course, then the issue comes down and whether or not I agree with your exceptions to the commissioner's finding. That's what Mr. Cross is saying, that there's not very much use for them to go to mediation because they have the upper hand. Because I'm kind of presuming what the commissioner says is correct, you know. Or it's presumption. Would you agree with that? I'm supposed to. How do you think you don't come in even on these things, do you? So.
Your Honor, my philosophy.
I'm asking her.
Your Honor, we understand that the court is looking to what the DRC found in his recommendations. However, we believe that he did not properly apply the presumption under the law to the evidence. And because of that reason, we don't believe that you should agree with his findings.
Well, you wouldn't have filed exceptions, but when I come in it presumed, or what's the level of proof you think it's necessary for me to have to overturn the commission?
Your Honor, I would have to.
I mean, you're asking me to do that. So if I'm thinking, you know, the commissioner is, I presume what he has is correct unless some standard of proof has to be met, clearly erroneous, you know, what is it, you know?
Your Honor, I'm not certain whether that would be a de novo standard, whether it would be abuse of discretion. I have to.
Okay, now let me ask you something. Can you walk back there in the room with Mr. Cross and tell him exactly what it would take to make your client happy with this? If he has an exact proposal, it'd be easier than wondering. You agree with that, Mr. Cross? And you can present that to your clients. And if we can't agree, then I'll decide whether we go into mediation.
Your Honor, my client is here, and will be happy to do that.
Yeah.
We will never agree to modify the DRC's recommendation regarding when the child starts school. That's one of their reasons.
What is the issue about when the child starts school?
The issue is that my client lives in Sparta. And so when the child begins school here in Clinton County, he's not going to be able to exercise as much parenting time with the child just because of the distance that he's going to have to travel in order to have the child at school. So the longer that we put off the child beginning school, which we requested 4 years old, they requested 3 years old. If we're able to put off until 4 years.
Who moved to Sparta?
They never, the two were never together, Your Honor. My client has always been from Tennessee, and Mr. Cross's client's always been from Clinton County.
He's not from Livingston, really, but he moved to Sparta.
Yeah, so when they were in a relationship, were they here in Clinton County?
Your Honor, they were not in a relationship. This was a very isolated.
Well, they were briefly in a relationship, or we wouldn't be talking about this, I would think, so. Well, I don't see, so the decision is when the child starts school.
That's one of them, Your Honor, but also the schedule, as far as up until then, my client has requested to have equal parenting time. And at this point, he's getting
Standard.
about 30 something hours, I believe.
The commissioners here, what is standard now here? If you say a standard visitation,
Visitation.
yeah.
Presumably 50.
Well, I didn't ask what the presumption is. What are when somebody says standard visitation, what are you doing is if the child is here in school?
You're talking about what we used to call standard visitation?
Yeah, what we used to, but it's still in these orders. We know we don't go. We know we don't go back and reopen these orders. I mean, we've already gone through that stuff, you know.
We go back to the every other weekend, one weekend.
1 week.
One
day a week.
And does this predate this presumption?
No.
Okay. Okay.
Well,
I understand. Well, and you stated, well, yeah, I understand what you're saying. You stated your reasons in there why you, yeah. So it would appear to me that unless you can reach an agreement here, that I'll just have to read the report and see what the reasons were and think that they didn't get the 50-50. And we haven't reviewed that yet, have we?
We have it waiting to be reviewed in the motion for mediation is filed, so we
Yeah.
held on to that to see.
Well, y'all go back there and see if you can, but I will tell you right now that I'm not inclined to delay a child's educational opportunity based upon the parents not living in the same area and that it would affect visitation during that time period. I'm not inclined to do that. So you're not going to get too far with that because I believe in early childhood education and I just think that that's the trend now. Now, as far as the moderations of visitation by this earlier start at 3 years old or whatever it is, then maybe there should be more generous terms of visitation because of that, if it's not practical. So go back and try to work something out and I'll stay around a while while you do it, okay? Haddocks versus Shelton. Yeah.
Your Honor, that's my motion for reviver for judgment in order of sale. That's passed.
Now, the reviver is okay, and you've had was there a specific piece of property put up or something to secure this?
This applies to the judgment lien that Weldon's had.
Yeah.
On a portion of this tract.
Yeah.
And now it gets a little complicated.
There-
One of the heirs is.
Yeah, I read it. I read it.
Convoluted, but I think it's.
Yeah, so one of the heirs, are the rest of the heirs trying to sell the piece of property, or are you gonna sell it for indivisibility?
Well, we're gonna sell it for indivisibility.
Now, is that included in the pleadings?
Yes.
Okay. It's kind of unusual to see both of them included in the
It's-
pleading.
Yeah, we had a lien on third of it.
Yeah.
But once the other heir assign their interest in us, we can move for indivisibility now. So it's been a lot of trouble. Sorry, we couldn't get it done before.
Now, the one that you had the lien against is the one that assigned the portion, or there's someone else?
No, one of the living heirs signed us.
A different piece, their share, which was not the share that you had to lien on.
Correct.
Okay. So you got standing as a co-owner of the property and also as a lien holder.
That's correct.
Okay. Well, I'll sign that.
I'll tender.
Send an order. Don't be too generous with yourself in the order. Set it out because it's a little convoluted. I will tell you. Okay. Amanda Brooke Lawhorn versus Joshua Lynn Lawhorn.
DRC.
We're allowed to get that one resolved according to.
It's been referred to the DRC.
It's referred to the DRC.
Yes.
So if you call him and tell him that it's resolved, he'll be happy.
We've done that.
Okay, good. Johnson versus Stewart.
That's fine, Your Honor. It's a quiet title action. We've done as good a service as we could get.
What is this? This is a piece of land and you never gotten service on any of the people that I'll get behind the podium so I can hear you a little bit better.
Your Honor, the Johnstons own a piece of property in Dale Hollow Manor. There is a lot that adjoins their property that is entitled. It is titled in the name of Lisa Stewart.
Yeah.
Lisa Stewart took title to this property in the 80s. She's dropped off the face of the earth. We served her Secretary of State.
Yeah, but how are your people claiming ownership?
Well, adverse possession. They've been mowing it for years.
Well, Moen didn't establish adverse possession.
Well, mowing, everything else.
Built a fence. That bothers me a little bit, that they haven't made any allegations that they built a building on it or fenced it or anything.
Couldn't do that because they didn't have time.
Well, I know, but they didn't do it because they didn't have title to it, does not help their adverse possession claim very well.
Your Honor, it is part of their yard. It's been part of their yard now for in excess of 20 years. And it's interesting, there was another tract of property that Ms. Stewart owned on the other side of this property that was title was quite, I think Mr. Psalm did that several years ago, did you know? This woman just disappeared. So
Only problem I have about it is whether or not there's any evidence here that they exercise the sort of dominion over this that would let them adversely possess it. And I don't think mowing it and considering a part of your yard does that.
you're saying if I have a yard and I'm for 15+ years, I mow the majority of this entire parcel, but that doesn't meet the requirements of open.
I'll give you an opportunity to brief that.
Okay.
I hope you're right,
I think
because I've been mowing some stuff for 20-something years. And I'd sure like to have it, but the people, won't sell it to me, and
That Darryl Coffee, you can just, I'll call him that.
yeah. But that's the only problem I have, because if they made allegations that they'd exercise other dominion over it, but they didn't.
Well, I will.
Am I right in the pleadings?
I think we let adverse possession.
Well,
I think that's.
yeah, but I think you have to manifest some kind of, but just brief that one little issue and I'm ready to sign it, okay? Westlake Services LLC, DBA Westlake versus Hancock. Yeah.
Plaintiff, notice that their pleadings are in Wayne County. Apparently the case is here.
I read that.
Pointed that out to them originally. And they say, yes, but the case is here, so.
Well, I've read this, but I've forgotten this one. It paled in comparison to these other things, I guess. I don't know.
Exactly.
What is the issue here?
It's a contract case.
It does what?
Default judgment.
It does what? What is the contract? What does the contract do? Give me that file. I read that. Well, there was an order of dismissal signed, the reason I'm asking, against Joseph Rojob, also known as Jose Jopop, also known as Jose Hernandez, and Genevieve Sente. So, and that is signed on the 7th day of October this year. So I was trying to find out if there are other party defendants. So I don't know what, if these other people, it says and others, but I don't see where the others were named in the original complaint. So that's the reason I'm asking you what this is about. Do what?
So you don't have a judgment to sign anyway, if you want to. It's said in Wayne Circuit. But, you'd like me to correspond with them about that? Or for me to-
Well, whose case is this?
Please?
You're coming as the master commissioner here, or is
No,
it?
no, I'm coming
Who you
Here
represent?
anywhere.
Well, I see David Cross is he still, did he leave? Maybe he'll,
What's I done this time?
well, you got me to sign a agreed order of dismissal against Jose Rochap and Jose Hernandez and Genevieve Sante. Do you remember anything about that?
Agreed, I didn't get you to.
Well, I know, but you submitted it, looks like, or somebody, or Pamela Petus.
I think I did prepare it perhaps submitting.
Well, you know what this case, what's this case about?
One about somebody had borrowed a vehicle and had a wreck. Question whether it's been misappropriated or borrowed. I'm thinking about it.
Again, this is all I've got. No, I don't describe it very well. It's not Wednesday, it is here.
May I look at what you have? So
Yeah, here's an affidavit that might explain some of it right there. Yeah, I'll take it out there. I just thought the whole thing was rather strange when Catherine versus Anderson. Y'all take that back over and look at it. Catherine versus Anderson.
mine, Your Honor.
Yeah, I'll pass over it for a second. Smith versus Brown. Is that yours, Mr. Little?
This is not the same case, Your Honor. This is the one I had with Salina Insurance versus Jose Rojo.
So that's entered in the wrong file.
Correct.
Okay, well, that explains why. Okay, this is the Smith case versus,
It's just, judge. Quiet title. The reason judge's case was drawn. They would show me the title search. And found error in some deeds, at least that's what he considered the percentage of ownership. And one of the
we'll get what, tell me what the error was.
the deed said 1/8 interest, the deed should have said 1/4 interest. One of the brothers who's still living, he came to my office and signed a quit claim deed for his interest, so these other two were deceased. And we filed a suit to quiet title this parcel property, which is part of the title source for the subject property. The error was in the
So you had a deed from Donald Brown and Rex Brown, and later on you found out that the deed stated an 1/8 instead of a 1/4. Is that what you're saying?
correct.
And now you've sued, but okay, that sounds good enough to me.
I thank you, Judge.
No problem.
I may be-
Sure, have a happy holiday, Mr. Little. Okay, Four Guys Diving LLC versus James Miller.
Master of the fall judgment, Your Honor. This is a gross semblance of a pro se answer was filed by the defendant. He refused to admit or deny, he didn't make any specific.
This was fixing a boat, right?
Yeah, of getting the boat out of Wisdom Dock. And so I thought, well, the best thing for me to do is enter some requests for admissions, and it's been done well over 30 days ago, and I've heard nothing from him. And I believe he wants to be a lawyer, he needs to practice law and not just file the weakest answer I've ever seen in my life.
I, James A. Miller, 132 Hyatt Road, Baghdad, will neither acknowledge or deny this debt. I do not agree to mediate. I wish for a jury trial, not a bench trial. Well, he's going to get half of what he wants. He's not going to get a jury trial, and he ain't going to get a bench trial. So I guess it's turned out pretty
I
well.
will enter a That's all, Your Honor.
Okay. Okay, now. Midland Credit Management versus Tanya Shelton. Yes. I'll get back to your case, right?
This was, I believe, no, it's not. This, I believe, was filed in the wrong for the liquidated damages stated in the complaint around $729.
Well, I'm not going to dismiss the case,
Okay.
but I will remand it to the district court.
Yes, sir.
And then once they get down there, if they find that you're incorrect upon the damages that they claimed, or it exceeds their jurisdictional amount, they can send it back up.
Okay, that's fine.
Okay, if you prepare an order, to that. Okay. Okay, now, let's go back to Mr. Cross, you got Catherine versus Anderson.
Just a motion for default, we've got this service on, nobody heard from.
What is that case about?
It's a custody case.
Okay, go ahead. I'll grant your motion, but I want you to put in there that since there was not an appearance or answer, that if she has any objections to the order, that she should appear in the Clinton Circuit Court on January the 13th. Okay. You know, let's go back, Mr. Sohn, now that we found out that there was an erroneous filing, now that it threw me off a little bit.
Yeah, this is, they contacted me late Friday.
Yeah, that's okay, I understand.
Finally agreed on like Saturday, they sent me this stuff, which I didn't come to the office to pick up.
Okay, I understand.
Today.
Okay, what is this about?
Figure that out. Come back later and then we talk.
Do you know what it's about?
I mean, I can look at the file.
Well, I can look at the file, but I'm telling you, I'm looking at the file and I can't tell what it's about. It's some kind of a agreement there with 24% interest in it or something, and I can't.
So here's a 15. And do the
It's a vehicle sale. It's a 2012 GMC sale. It's a truck.
So just a financing statement, somebody sold the truck.
'27 auto sales in Somerset, Kentucky. I'm not sure. There's a question as to why it is here and not supposed to be in Wayne County, because it looks like the auto sales is out of Somerset and the defendant lives in Monticello.
Submit me an order, send it back to Wayne Circuit Court. And you got this judgment here, okay? This judgment says, it's further ordered to judge that the plaintiff Westlake Services, DBA Westlake Financials, have recovered from defendant Ridge A. Hancock jointly and severally. Well, I don't know how you can collect from one person jointly and severally, but.
Well, the buyers are Tia Hancock and Ridge Hancock on the contract.
But that, okay. But
And
they
the
didn't-
summons has them as an alpha address.
But it doesn't include anybody but Ridge. Yeah, but in the judgment. Defendant Ridge A. Hancock jointly and severally. Do what? No, this proposed judgment, default judgment, is suing Ridge and two other people that bought the vehicle. And now they're only seeking judgment against Ridge, but they say jointly and severally. So I think they meant to put the other people in the judgment also. And they got the principal amount, they got 15% interest from the date just plus cost allowed, reasonable attorney fees calculated on the principal balance at the rate of 30% for the sum of $3,900. And I don't understand that either. Why they want, what the 30% of, I guess, principal, so they're getting 30% recovery on it, I guess. And they want that over and above the 13,000, which they might have a contractual agreement to pay attorney's fees. But it doesn't say that. Yeah, it says pursuant to contract.
I don't remember.
What does it say in the complaint?
Actually, the complaint only names Ridge Hancock. And it looks like a summons was only sent to Ridge.
So this and others is just an error up there.
Well, I mean, her name was on the contract.
But they didn't file suit.
It doesn't look like they filed suit again, because there's the complaint.
That's right. I thought it was confusing. You see they got here. Jointly and several.
But when I go, yeah, and see Ridge and Tia are on the buyer's names on the contract.
See if they've got a attorney's fee. I'll look for the attorney's fee.
He's the only.
He's the
party.
only party is what we're telling you. So this and others up there at the top, and then this jointly and severally in the body of it's wrong.
The contract says reasonable attorney's fees. I don't see a interest.
But reasonable attorney's fee be calculated on the principal balance at the rate of 30%. So that rate of interest, principal balance, is 30. So they're asking a 30% recovery on this. Okay.
The attorney now is firm and there's no contract for that contractor selecting the attorney.
No, it's the contract that the buyer of the vehicle signed with the seller that says reasonable attorney's fees. And what they're saying is a reasonable attorney, it's worded in an odd sort of way that they had it on a 30% recovery, and that's the 39.16. And now they're wanting interest at the rate of 15%. What is the judgment interest now?
6 statutory. Statutory.
Yeah, can that be overcome by a contractual agreement?
Yeah.
And so what they're doing, they had a 24% interest in here and they've reduced it to 15%. Okay, good job. That'll pay you a lot for sending you one like that. Okay, is there one other civil matter? What do y'all have?
It's the add-on. That was the add-on.
You got, y'all come to any court? Yeah, what have you got? Okay, well, we'll just look and see what we think about the commissioner's thing, and you can send me something if you want to on what you think my standard of review is, okay?
Yes, Your Honor.
Thank you.
Yeah, okay, you'll have a nice holiday.
Since I was on both these motions, but myself and Mr. Wilkerson has come to an agreement on all issues.
I don't want the last case I do here in the year to be an agreement, but I guess I'll overcome that. So,
Where do you want to get those?
yeah, I've got a
I would
feeling.
just like to stop the agreement for the record, so we do have it on record.
Okay, have the parties here to make sure that they buy in here. Okay, are the parties present?
They are.
Okay, y'all, why don't y'all come around here? And so I can get you on camera. Okay, who's gonna recite?
I can recite, Your Honor. It was, on behalf of the petitioner, we had called both of these motions. The first motion was for an expansion of visitation. The parties have agreed beginning this Friday, December 17th, that the petitioner will receive visitation beginning on Friday at 8 a.m. First, at school in session as soon as school is dismissed. And will receive the children until Saturday at 6 p.m. and Sunday from 8 a.m. until 8 p.m. This will alternate every other weekend. The petitioner will have this visitation for 4 months. In 4 months, we will be granted, or we will be allowed to bring another petition for an extension of visitation. Previously, in this case, there was a friend of.
Or you can agree to this.
But we, or yes.
Or seek an agreement. at that
Or
time.
that's
Okay.
correct. The parties have agreed to mediate after the holidays, and so.
Well, let's talk about the holidays. We got
We
agreement.
have figured that out too, Your Honor. So for Christmas Day, my client will receive visitation from 2 to 8 p.m. on Christmas Day.
So she gets Christmas Eve and after Santa Claus comes.
And he will receive from 2 p.m. to 8 p.m. on Christmas Day.
What about the day after Christmas?
Visitation will resume as normal as of 8 p.m. on December 25th. So
What is
whatever
that?
the-
That would be some-
Sunday the 26th.
It would be back to.
Well, I'd like for him to have the Christmas to the child on Christmas Day and Christmas night. Okay, she's having a child on Christmas Eve. He needs to have the child overnight for Christmas. And then you can resume the normal visitation, okay?
Okay. What I think. for-
How old is the child?
There's 3 children.
Yeah,
I think for both purposes, I think we need to agree on what time visitation will, what time pickup or drop off will be on Sunday at that morning.
On the 26th?
The 26th.
do you take the children to church when you have them?
Yeah.
Well, do you take the children to church? Okay, well, here's the thing to do it on. Is the 26th on a Sunday? Okay, and how far apart do y'all live? Okay, what time does your church start?
Right now, it starts at 11.
Okay, well, have the children back over there by 9:30. So she can primp them up a little bit to go to church, and then that way you get them on Christmas night and you'll have them overnight. Is that okay with you?
So Christmas morning, I wake up there.
Christmas, no, the day after. They go over there at 2 o'clock or whatever on Christmas, and they'll stay that night. And the next morning, he delivers them back to you early enough for you to get them ready to go to church, okay?
But I'm talking about pickup and drop off. The parties will now meet for pickup and drop off at the IGA in town. Previously needed, or he was previously going to pick up and drop off at her parents' house, and just to have a middle.
Where do y'all live?
Greenbrier. Parks County.
Yeah,
There hasn't been any issue. I mean, I agree.
okay, well, that's fine.
IGA.
I was trying to think someplace closer to the IGA. Okay, well, that's fine if the IGA is all right.
The parties have agreed on a family counselor. His name is Mark Speck. He's with Rise Interest in Monticello, Kentucky. Parties agree that their first counseling appointment will be within the next 30 days. I personally reached out to Mr. Speck and he's got availability to do that.
Okay,
Lastly, Your Honor, as stated, the parties have agreed to mediation. We're going to work that out, hopefully conduct that in January.
have you agreed on a mediator?
We're going to try informal mediation at first. And see if
One
that's-
day, Your Honor, I think
Yes.
that's the prospects of being resolved.
And if not, then that won't be
we get the cases removed, we'll do the mediator. I had filed a motion for show cause. The respondent has acknowledged that there has been some miscommunication, so when we sit down for mediations and the time that was missed, we'll hopefully have an agreement on how much time that was.
Yeah.
And make up that miscommunication at that time.
Well, it's easy to do that sometimes in the summer when things aren't so complicated, you know, and school's not going on, so we can do that. Okay. Okay, you agree with this, ma'am? You agree with it, sir? Well, I hope in the future, you're both going to be parents of these children forever. It's going to become more difficult as they get older and hopefully get into happy relationships and have children of their own on where you're going to go for Thanksgiving and Christmas, but they'll be old enough to make those decisions themselves. And then who's going to see the grandchildren, but you're not the only people in the world that have complicated relationships. And what you got to remember is you got to focus on what's in the best interest of those children and give it up sometimes on what you want to do. And it's hard to do sometimes because you're just going to have them for a little while. Right.
Your Honor, there is one thing that the respondent asked or articulated on the record about part of this agreement. So Mr. Berg is remarried and there is he has some stepchildren in the home that he has every other weekend. So we have conducted the schedule. So during the initial phase in for his children spending the night, they can do so just while his stepchildren are not there. That is just the beginning until.
How old are your stepchildren?
They're 6, 8, and 2.
And your children together are what?
Are 15, 13, and 8.
And the 15-year-old is having some problems. So we're doing this to hopefully help facilitate that relationship.
Well, you know, the thing about it is, if the child is or isn't having any problems, it's for that child's protection to stay away from people that might be saying they're having a problem. You know what I mean? It goes both ways. Okay, thank y'all very much.
Thank you, Judge.
You'll get it circulated to each other and send it to me and I'll sign it. Okay.
Okay, yes.
Thank you, Judge.
Okay.
Approach, Your Honor.